Yes, Mr. Advocate Jayant.
My lord, the matter which has been, my lord, assigned before my lord and my lord Justice Supratim Bhattacharya, my lord, that review application, my lord, not before the vacation, my lord, I quite understand, my lord. Could it be, my lord, immediately after the vacation, any day, my lord, subject to your lordship's
Can
convenience?
you ask your junior to mention immediately after the vacation, because I do not know now what will happen.
Very well. Well, on the reopening week, my lord, my junior will mention it.
Reopening, please mention. I will. Or you hand over the slip. कुछ अगर देखे नहीं जस्टिस भट्टाचार्य की रकम থাকবে पूरे নিয়ে. Hand over the slip and please ask your junior to mention after the vacation.
With the another matter, my lord, in the monthly combined list, my lord, that Manor Hotel matter, my lord, your lordship, recollection, 80 crores are due. My lord, give some precedence after the vacation. But I'm not, my lord,
Right. After the vacation,
please.
Because Mr. Advocate, the problem is the pressure of motions. Some matters are upgraded. Also, I cannot reach to those matters.
Because of the, my lord, the enormity of the amount, my lord, public property, my lord, is
Right, I will consider after the.
May I hand up this, my lord? It
Yes.
is 867 monthly list.
Yes. Have asked your junior to indicate the urgency.
Very well. Very well.
ওটা দিয়ে দিন. Yes.
Right.
Hand over the slip after indicated.
Right.
Thank you. Yes, Mr.
I have already affirmed the motion. I could not file it yesterday. Could not file it yesterday because they say if I file it today, number will be given on Friday, on Wednesday, 2 days after. All checking would be done, all these things. Then
Can you not wait till Wednesday, Mr. Chatterjee?
no, if it is Wednesday, number is given, then it will appear during also on Thursday, and Friday is the last day. That's why I cannot take the chance. If you also kindly give me leave, if any KBD is there, I shall serve notice, let it appear on Tuesday as new motion.
Can you move on Wednesday? Please give the date on Wednesday, because if all matters, some matters are urgent, which cannot wait for one day. I am directing, because the department, they have to scan, they also want some time to get this, those paraphernalia. On Wednesday, bole, pore din.
Lord, I had mentioned a vacating application on 8th of September. Your Lordship was pleased to allow the mentioning. My Lord, thereafter, my Lord, this application has never appeared in Lordship's list.
Vacating application?
Vacating application, my Lord, the entire my civil suit has been, my Lord, stayed by the Lordship. এটা আমি করেছিলাম 8 তারিখে.
That extreme urgent situation, my lord, this cannot wait for even one day, my lord. That's why I'm before your lordship for to disturb your lordship. But the difficulty is, my lord, this suit was filed, my lord, to prohibit certain persons from conducting Durga Puja in my premises. Lord, I'm a builder. I have it's a project. Lord,
that has been allowed. Puja has been allowed.
Lord, injunction, caveat was there. I was directed to serve and come back. Lord, I did that. They came, appeared, filed Order 7 Rule 11. I made an application so that preponement can be done. Preponement was done. Injunction was fixed on 19th of September, and 8th of September, Lord, matter was taken up for Order 7 Rule 11. While disposing of Order 7 Rule 11, Lord, the date, next date for hearing of Lord injunction has been fixed after Lord, Lord in the month November. Lord, I will be only seeking with your lordship, Lord, to direct Lord, the learned trial judge so that Lord, next week, Lord, it can be taken. Lord, this Lord, if this can appear, Lord, today.
Have you affirmed this?
The number is not that. The reason is, Lord, because the handwritten certified copy type, that's why I could not file yesterday.
Hand. Leave to file.
Leave to file. And
to move. Leave to file and move today. Supplementary list.
May I have Madam Secretary leave to mention?
Mr. Kormukar, please give the cost title so that.
Yes. May I have Madam Secretary leave to mention on urgent matter, and this is a custody matter. The consent mutual divorce between the parties done, the custody was given to the mother. In the meantime, the act filed with the father. In the act I filed a 711 that has been rejected. Now, after my rejection, they are tomorrow moving an application for the interim custody. So today, the moving an application for interim custody of the minor daughter, during the puja vacation. There's a
move. This is a difficulty.
My lord, In the 13B application, my lord,
14 to move, no order has been passed.
for
Cannot be
if the
stayed.
order comes today, my lord, I have already filed an application, my lord.
It will be appearing, yes.
And in the on Monday at least, my lord.
The date you have mentioned in the presentation form, it will appear on that date, yes.
Going to mention one matter for extension of interim order.
And over this,
For correction, my lord.
you have indicated the correction.
No, my lord, I have annexed the order sheet. What happened, my lord, tagged one matter, similar order challenged by opposite party, but the matter CO number has been written, the order has been passed in this CO.
No, I could not follow.
The order passed in CO number 3383, and the along matter will be.
Order has been passed in CO double three eight
Kindly see
three.
the last line, my lord.
The other number has to be indicated. What is the other number? Please make that.
2676.
Please mention that. Please mention that. It is দিয়ে দিন, please. List. Order to mention দিয়ে দিন.
For
My lordship,
4 years.
and for the petitioner, my lordship, there is a correction in the order, my lordship.
Yes.
My lordship, I have indicated. My lordship, in the second paragraph of the order, my lordship,
This is not indicated. Before the
my lordship,
pursuant to the directions that is
CGM, my lordship, but
CGM at Barasat.
yes, my lordship, and also
right.
in the last paragraph, my lordship, in the second page, the fifth paragraph, my
Where
lordship.
is that order?
My lordship,
Have you annexed that?
yes, my lordship. All the orders I have annexed with the my lordship. My lordship, the last order, my last week.
Acha, Ashun. This
Lord, I appear for the petitioner on 11th September. My lord, kindly have a look at your lordship's order. My lord directed not the wife to produce the child to City Center 2 Mall on my lord the next Saturday.
yes, what happened?
Lord, Saturday he was not produced.
Sunday, my
Lord, I tell you, lordship, Saturday he was not produced. The lawyer was present when your lordship passed the order.
Lord, my wife has blocked me. I can't contact. My father-in-law informed me when I access WhatsApp that unless I get a order, copy of the order, we are not going to listen to you. Then we issued a notice of contempt. We said that please comply. Sunday also I'll be waiting in city center too. Good sense prevailed. Seeking with the sun on Sunday, not on Saturday but on Sunday. When we said that we'll be again waiting on Sunday, she came. So visitation happened. I do not rely upon your instructions.
Lord, I have instructed on the.
No, I'm asking you.
Yes.
Client do not also rely upon your instructions or you have instructed her accordingly. Please make submissions. I will record that.
Yes.
No, Lordship, I had
And I will
instructed.
proceed against accordingly. against your
Lordship, I had
client.
instructed her to visit, but she was.
She did not come on Saturday. Why? Did you instruct her to come on Saturday?
Absolutely.
Yes, she did not comply with your instructions. If that is so, please say I will record that and I know how to proceed.
Yes.
I know how to proceed.
এটা important. বউ যে চিঠিটা পাঠিয়েছিল সেটা কার?
Yes,
Lordship, if I may.
yes, why you did not produce on Saturday?
Lordship, we had instructed the client, but since the order was not uploaded by then, she was.
The order was passed in your presence or in your absence?
Lordship, it was passed in my presence.
Yes, so did you communicate that fact to the client?
We did, your Lordship.
Right, I'm recording that fact. Ashun.
Yes,
Six,
Mr.
my lord, I am for the petition. My lord, pursuant to your lordship's direction, my lord, I have served. And they have chosen to, my lord, they have refused the,
What have you done, Mr. Chakravarti, Mr.
my lord, that puja matter, my lord.
No, that I understand. Why they are avoiding to come? What have you done?
Nothing, my lord. My
Afraid-
place, I am,
Afraid of you.
my lord, they are, every year, my lord, they are
No,
disturbing.
they are
the puja.
afraid of you.
No.
Why?
Caveat lodged, no objection
That
given,
is why
my lord. Then what, my lord, what?
the advocate also had to give no objection. Yes, yes. Earlier year also you,
Yes, my lord, this is the police report of the earlier year, my lord.
what is the ground for objection?
Objection, my lord, kindly see impugned order once, my lord.
In this matter, my lord, I have been requested to appear, my lord,
Wait.
I have not yet received the vocal number and the.
This is the-
Your lordship, my lord, kindly fix it on Monday, my lord, or Tuesday.
This is the way, my lord, how this.
Puja, when they will make arrangements,
My lord,
there is also
Puja permission was not refused, my lord. Puja permission was not refused.
Puja is there, my lord, but I sought
Only,
for
my lord,
police,
he is seeking
police help,
permission
my lord, so that they cannot create any, my lord, hindrances in the puja.
then what is the difficulty? If the police rules, it will be also for your benefit.
And this is the,
And, I will also say that the conditions, that will be better. If they violate any of the conditions and permission, police.
Keep the matter on Monday, my lord. I have not yet received the copy of the application, but let you.
well, they have refused my,
Sir Ganguly, now he has instructions to appear.
my lord, caveat,
Earlier-
no objection, thereafter fresh service, my lord.
Now he is
refused.
appearing.
My lord, this is the way how to, my
Can you
lord,
not
state
come,
the
you
entire
can
thing.
file your Vakalatama, come at 2 p.m.
Yes.
Come at 2 p.m. Mr. Ganguly, give him a copy.
My lord, I'm serving a copy hearing now, another copy, my lord.
Take the matter on Monday, my lord.
Why?
My lord, kindly allow.
Monday,
go through the
many
procedure.
matters are fixed.
Kindly allow me to go through the procedure and I'll
This is
take
not
matter on
review.
Monday, my lord.
This is.
You look it and fixing it at 2
Kindly
p.m.
fix it on Monday at 10.
This is the-
What is the difficulty, my lord?
The filing your Vakalatama today,
File it today, my lord.
the learned advocate appearing for the
I appeal for the petitioner. Lordship, in the order dated 16th September 2025, there is a typographical error. In paragraph 8, Lordship, it has been stated as first court at Alipur. It should have been first court at Arambagh, Hooghly.
learned advocate, it should be
May I please, your lordship? My lord?
Yes,
I'm for the petitioner, dependent petitioner before lordship.
yes.
My lord, my application before lordship that I couldn't pay the amount that I was directed towards allowing my application under Order 9 Rule 13 toward cost. My lord, amount was 26,000 rupees. So, my lord, I couldn't come up, my lord, within the 150 days that was the scheduled. My lord, I couldn't pay. I made an application that was rejected. So I couldn't
Rightly.
pay this. My lord, then your lordship directed my lord to serve
Yes, yes.
Lord,
But what did I more say?
40,000.
Yes.
We agreed to, yes,
Tell that.
yes, your lordship. We agreed to pay that, your lordship.
He is agreeable to pay 40,000 now.
No, Lordship, I have a strong objection against this.
You are not ready to accept 40,000.
Lordship, kindly see. Kindly see the list of dates.
Yes.
It's a suit.
But that was allowed, only he did not pay the cost.
Section 106 of the Transfer of Property. The suit was filed in 1998. It was exported decree on 2001.
All right, then I will hear it after the vacation. I'm keeping it after the vacation.
See, this is a revision application filed by this petitioner is pending. I don't know, nothing has been disclosed. What are the revision?
All right, so I'm posting it after the vacation. The learned advocate Yes, Mr. Raichodhuri. Where are they? Yes. Yes.
My lord, so bank is concerned, there is an annexure in the writ petition also, few points, which is a mandate for us to follow so far as the RBI
No,
guidelines.
he has no difficulty with regard to that. Only he will be, because the nominee has been allowed, he will be permitted to remain at that point of time.
My lord, this person, the lady has died. Now, in the records of the bank, only the nominee, one brother is there. So, under special circumstances,
Yes, yes.
if your lordship passes any order, we
Yes.
shall come
I will
back.
only direct his presence at the time of.
Apart from the witness and the video record,
Yes, yes. I'm not.
we will,
All others will be present, and Mr. Raichodhuri, you have to bear the cost.
because
My lord, one more submission, my lord.
Who are you?
I am for the defendant number 3, lordship.
Yes.
My lord,
Yes.
the order of the learned
Three.
court below did not
Even
say,
number 3 means your brother. Oh, yes.
the order of the learned court below did not say the security in question, lordship. The ornaments, in case there is no amicable settlement between the parties, then the ornaments will take in charge by the receiver, lordship.
Yes, yes.
But
Court below. But no difficulty. I am not disturbing that. Only at the time receiver will take. No modification with regard to that. You being the nominee is being allowed to be present. He will also remain present at the time of breaking. Nothing more.
But if there is no settlement, my lord, that will be decided by the court.
Yes, yes. That will be. I am not doing anything with
No,
regard to that.
they are trying to say how will the receiver, because the receiver also.
That's receiver. That will be done by that court. I am not going into that.
And my lord, the cost of whether we are to keep the valuer or not, the goldsmith, is that necessary? Because if there is a distribution outside the locker room, bank's responsibility.
That is, the learned trial judge has allowed that. I am not interfering with that.
No,
Now
it's to intimidate us. We cannot, the parties, because they, unless they say.
that is for the parties. If they do not do, you will not do. That's, I'm not saying that.
Manager's responsibility ceases as soon as the receiver takes the custody of the jewelry.
So I'm only
Distribution.
modifying this by allowing him to participate. I am not saying. Ashun, this application under Yes, call the next matter.
Item number 10.
I'm appearing for the opposite party.
But I'm for the
Yes.
petitioner, my lord.
Yes.
I'm for the petitioner, my lord. This has come for extension of interim order.
So Halder, what have you done with the petition? Yes. Extension of interim order.
Interim order, my lord. Interim order was granted, my lord, till end of September.
Yes. What is the impugned order?
Impugned order, my lord. I'm telling, my lord.
There was no irregularity.
Father
this
died.
order.
Ashun. After hearing the
Can was filed that was disposed of. It is wrongly appearing in storage list. Can one.
it is pointed out.
I am for the petition in this matter, madam.
Yes.
Well, the interim for extension of interim order, it's till September 2025.
For the opposite party, after hearing the learned.
44.
Malad, the main opposite parties are not appearing, Malad. On the last occasion,
He is the supporting opposite party.
Malad, may I just
You
indicate
have
one?
brought her,
No,
not
Malad.
the main opposite party.
Malad,
Have you served notice upon the main opposite
I've
party?
served. Malad, what has happened, Malad? They are also not appearing before the learned court below. The learned court below has noted in the
Learned advocate appearing.
They are not appearing since February, September 2024. Malad, only if your lordship kindly adds a rider. If they don't appear, take steps.
Petitioner is directed to serve to communicate this order to the petitioner is directed to communicate this order to the non-appearing opposite parties.
No, Malad, what I am praying, Malad, if they don't take steps before the learned court below, Malad, the learned court below may take steps for.
Do that there. Yes.
Malad, they are.
আচ্ছা এটা ছেড়ে দিন লাস্ট সেন্টেন্সটা কেটে দিন yes call the next matter
Item number 12. I am for the petition.
Contested application after 12 weeks
The affidavit of service at last, Milord, I got my last friend. T of name, similar name, Milord, person is there, Milord, in the past, but I found fortunately.
My lord, the fact is that, my lord, if your lordship go through the CO, my lord, the second opposite party, his name has already been expunged from the lower court record, and in his place, another person has been treated as a president. And my lord, the first I have only
opposite party number
1 double I.
1 double কি ঠিক ফাইল দিয়েছেন না কোন ফাইল what is the item number
Item, Milord, it's CO 2751.
2751.
no that কি দিয়েছেন 2942 দিয়ে দিয়েছেন তো 2751
Milord,
পরেরটা ডাকুন, শর্ট পাস ওভার, নেক্সট নেক্সটটা ডাকুন, নেক্সটটা ডাকুন। এই,
13 Millard.
please take back the
I'm
please.
13 Item number 13
Yeah.
virtually. Millard, I'm appealing for the petitioner, Millard. Millard, kindly recalls yesterday, Millard,
Mr. Strategy, you have become a virtual lawyer.
what happened that yesterday, my lord has asked me to take instruction from the trial court's advocate that when I could file the written statement. My lord, the advocate has lost his father, my lord. He will be joining profession on 24th of this month. So, my lord, he says on reopening, my lord, they are reopening on 27th or 26th, my lord. My lord, on by 30th of October, he shall file and give a copy, and the next date will fix from the court, my lord, 12th of November.
That is good enough, but my lord, kindly looks into the
When you
conduct.
said good enough, I was saying that, but
No. That is good enough, but the submissions are good enough.
Yes.
I cannot dispute the submissions of Mr. Chatterjee, but kindly look to the conduct of the parties.
Yes, he has to pay cost.
Yes, my lord.
We have already to this, my lord.
Loud.
My lord, my lord has. My lord, I tell your lordship, my lord, what happened, my lord. There is an order, my lord, whereby, my lord, court has directed me to pay a cost of rupees 2,000. That was under challenge.
1,000 is nothing.
No. What happened, my lord, the erstwhile learned advocate, Mr. Kamalesh Bhattacharya, in the trial court expired. My lord, he files a petition in the court below saying that he has paid the cost, but we don't have any document to cite and the court doesn't record any order to that extent. Now, my lord, after his death, I cannot retrieve any document from his chamber. Now, my lord, this new advocate is also helpless in that position. Now, my lord, be that as it may, if my lord sees the first impugned order, my lord, to cost, my lord, I would only say, I will leave it up to my lord, but only sees the first impugned order. My lord, within 15 days of service of someone, I have been put expert. Within 15 days.
That is the impugned order. It's difficult to get the
No, it's a certified copy. My lord, kindly
is annexed.
So why are we annexing the entire copy of the order sheet?
My lord, it has been taken up as a bunch, my lord. I cannot segregate. I could not segregate it.
Wastage of money.
My lord, the client has opted in that way. My lord.
What matters is the entire certified copy is not necessary.
My lord, if my lord takes up the 12th of May 2023 order, May 2023.
Yes. Now, Mr. Chatterjee,
my lord, sees the summons court record. The summons have been served on 29th April 2023.
You file your written statement.
Yes, my lord.
Examine his witness.
Yes.
Subject to payment of cost. Much
Yes,
cost.
my lord.
Cost, my lord.
My lord, that's why I indicated this. The first cost which was imposed, my lord, within 15 days, where statute provides me 30 days. I'm ready to put that cost and whatever my lord directs, but kindly considers the amount of cost in this scenario. Well,
Yes.
I'm not arguing any further.
Mr. Chatterjee, what according to you would be the reasonable cost?
My lord, 5,000 and that 2,000 to be added, my lord. 5,000 and that 2,000. The earlier 2,000 and now 5,000. Total 7,000, let it be, my lord.
So it
Because I was
strategy, it just does not justify the status of the appearing counsel of the petitioner.
Milord, then Milord, I am Milord logging on Mr. Oshik Chatterjee, let him appear, Milord.
No,
Milord,
no.
client is not in that position, not very well off. Milord, and Milord, if my lord sees the merit,
My lord, he
Milord,
can
then my lord will.
a power of attorney holder, he can appoint Mr. Chatterjee. He cannot pay cost of rupees 2,000.
No.
So, my lord,
Now he says that he will pay 7,000.
and my lord, one thing,
have been paid.
one thing, my lord,
been paid. 2,000 have been paid.
He says over and above, he will pay 5. So
2,000
7,000 you have to pay.
2,000.
Don't say that 2,000 will be.
My lord, 2,000 has been paid. It is his submission, but they have also challenged this
No,
order as well.
Now I'm Ashun. Acha, 16th of August, what happened on, by order dated 16th of August?
Milord, 16th of August, Milord, nothing has happened. Court has simply adjourned it.
Only adjourned. So 8th of September, what happened?
8th of September 2025.
Adjourning হয়েছে দাদা. That was also
Adjourned.
only the effective order is 10th of, no, 6th of February.
Yes, my lord.
Yes.
Because on 8th of September, my lord, the previous order dated 12th of May was
Correct.
set aside. It was considered set aside it was allowed, they were permitted to file the written statement subject to payment of 2,000 rupees.
By which order?
My lord, by
Lord, kindly takes up
8th
order
of,
dated 8th of September.
Yes.
8th of September. Kindly
Lord,
see.
my lord will
Was allowed subject.
see.
Yes. 12th of May, the one which says that it has been running ex parte against them, that was considered, that was set aside.
This application under Article 227 of the Constitution of India is at the instance of the এটা কি heading আছে? Extension. তাহলে ওটা একদম প্রথমে শুরু করুন. Though this matter is appearing under the heading extension of interim order, but with the consent of the learned advocates for the respective parties, the main civil division application is taken up for hearing by treating the same as on the day's list. So this application, paragraph 3, this application under Article 227 of the Constitution of India is at the instance of the defendants and is directed against the orders stated August 16, 2023, September 8, 2023, and February 6, 2024, all passed by the learned civil judge, senior division, second court at Alipur, in title suit number 540 of 2023. First up, by the order dated 16th of August 2023, the
Amendment application was allowed.
the amendment application
Without serving us.
was disposed of and pushed up. So that you are not challenging, Mr. Chatterjee?
No, my lord, now since my lord is allowing me to file written statement, I am not arguing on merits of those orders.
Yes.
I am not arguing.
Pushed up. By the order dated 8th of September 2023, the application filed by the petitioner praying for vacating the order of ex parte hearing was allowed subject to payment of cost of rupees 2,000. First up, the petitioner did not comply with the directions contained in the order dated 8th of September 2023, and for such reason the petitioner and also that the petitioner was absent without taking any steps. The learned trial judge proceeded with the recording of evidence of PW1 ex parte. First up, paragraph. Mr. Chatterjee, learned advocate appearing for the petitioner, submits that for reasons beyond the control of the petitioner, the defendants could not take, the defendants as petitioners herein could not take necessary steps in the said suit. Full stop. He further submits that the erstwhile learned advocate of the petitioner paid the amount of rupees 2,000, but he died.
Yes, my lord.
But
He expired.
unfortunate death of the erstwhile learned advocate for the petitioner, the petitioner could not collect the relevant receipt showing payment of the said cost. Full stop. Mr. Chatterjee further submits that the petitioner may be allowed to contest the said suit by vacating the ex parte order subject to any terms that may be fixed by this court. Full stop. Learned advocate appearing for the opposite party vehemently opposes the prayer of Mr. Chatterjee. Full stop. He submits that the petitioner is trying to delay the hearing of the suit. Full stop. Though the prayer of the petitioner for vacating the order of ex parte hearing was allowed subject to payment of cost, but the cost of rupees 2,000 was also not paid by the petitioner. Full stop. He submits that the learned trial judge was right in proceeding with the recording the evidence of the PW1 ex parte. First of all, heard the learned advocates for the parties and peruse the materials placed. First up, after taking note of the submission of Mr. Chatterjee that the erstwhile learned advocate paid the without entering into the dispute as to whether the erstwhile learned advocate of the petitioner paid the cost of rupees 2000, the fact remains that no document in support thereof could be produced by the petitioner either before the learned trial judge or before this court. First up, considering the fact that the prayer of the petitioner for vacating the ex parte hearing was allowed subject to payment of cost, and the petitioner claims to have paid the said amount to the erstwhile learned advocate, this court is of the considered view that the petitioner should be allowed to contest the said suit from the stage the suit was fixed for ex parte hearing. Full stop. Subject to payment of cost of rupees 10,000 by the petitioner to the opposite party within the time limit stipulated hereinafter. Full stop. By the order dated 16th of August 2025, the application for amendment of plaint was allowed ex parte, full stop, since the petitioner did not take steps at the relevant point of time. This court is not inclined to interfere with such order. Full stop. Mr. Chatterjee, with such order, as Mr. Chatterjee submits that he may be allowed to participate in this suit from the stage of allowing the application for amendment of plaint. Full stop. Allowing the stage after allowing from participating in the suit from the stage after allowing the amendment of plaint. Full stop. You have got this copy of the amended plaint. Yes. What now? Why are not in now? You are saying your written statement is ready. Now you are saying no.
No, Milord. Perhaps I have asked my client.
Milord, I tell your lordship, Milord, Mr. Paja has obtained the copy of the amended written plate, Milord, from the certified copy.
So then
Milord, we have. So, Milord, there is no difficulty. And Milord, Mr. Munshi is there, he will supply another copy if required.
So why
Milord, we are not standing.
Supply. You have got the Mr. Chatterjee, why are you complicating?
Appearing all along, he was appearing.
Yes. It is not in dispute that the petitioner has the certified copy of the amended plaint. Mr. Chatterjee further submits that the draft of the written statement is ready, but some time is given to the petitioner to file the same, as the father of the present learned advocate for the petitioner before the learned trial judge has passed away in the meantime. Full stop. In view thereof, in view of the aforesaid discussion, CO number such and such stands disposed of by passing the following directions. Full stop. The order impugned dated September
8 September.
8, 2023, September 8, 2023, and February 6, 2020, and February 6, 2024, insofar as the suit was directed to proceed, is set aside. Full stop. The petitioner will be permitted to participate in the said suit by filing a written statement to the amended plaint on or before October 29, 2025.
Let it be 30, Mr. Paja has said 30, if you check with that.
It is a holiday, Mr. Chatterjee.
Oh, achha. Oh.
October 29, 2025, subject to payment of rupees 10,000 on or before, subject to payment of cost on or before that, on or before the filing of the written statement before the learned trial judge. Full stop. If if the cost as directed herein before is paid within the time limit indicated herein before, the learned trial judge shall accept the written statement of the petitioner and shall allow the petitioner to cross-examine the and shall allow the petitioner to participate in the suit starting from the stage of cross-examination of W1. First stop, the learned trial judge shall proceed with the suit thereafter in accordance with law. But it is how that in the event the cost is not paid within the time limit as indicated herein before, or the document is not filed within the time limit indicated herein before, this order shall stand automatically recalled and the civil division application shall stand dismissed and the learned trial judge shall be free to proceed with the hearing of the suit with parties.
Now, Milord, only one thing, Milord, the trial court has not framed any issue. Let there be a direction to form issue because court is proceeding ex parte without forming an issue.
Do that.
An issue be framed.
Do that there.
Milord, affidavit of service be kept on.
Can dispose.
Milord, affidavit of service be kept on.
If
I'm so
any
grateful,
pending আছে বোধহয়।
Milord, affidavit of service be kept on record.
Can want to dispose of it. Yes, every service taken on record. Yes, next.
Order
Grateful,
number
Milord.
12.
12. ও পাস পেয়েছেন ওটা? Yes.
It's for extension. Initial order was passed on 2nd of August 2024.
Yes, I'm extending this.
My extend the matter, but my lord, thing is to some extent one double I, my lord, Roman 2. That person has already been expunged from the lower court
Not
record and
expunged, my lord, may I state? Lord, the schedule of amendment is not longish. It includes the expunging of name and Milord addition of parties without preferring order 1 rule 10 to application. So Milord, that is also Milord
Sir,
conspectus
after
of
hearing the Yes.
Led by Mr. Paul.
Yes.
There is service ballot. The preemption proceedings. By way of purchase, the preemptive became the quotient register property in question prior to the impugned transfer. That was the consideration before your lordship.
Nobody is appearing.
Up to September, subject to cash ballot, the what is up to September.
Have you served?
Yes, ballot. Out of two, no, three opposite parties are. बोलते हैं ना फालतू में. Two served, one is also served, but name is not appearing. Now it is one of the postal. But two has been name is there.
But the third one has not been served.
Delivered. It is recorded delivered, but the name is not appearing. But the ballot can. That is why ballot. Here from the same family members.
Affiliate of service filed in court today is taken on. Same order, same date.
Order dated was different.
Mr. Rai, you have not been briefed.
Same matter.
What same matter?
This is with regard to the same party.
He has not fled away. Maybe same.
This is same.
Let's argue on the merits. Let me decide.
You also decided same issue also.
Same. Yes. Yes, call the next matter. Same order কিন্তু extend করে দেবে।
Extension will be made. The
Extension.
practically hearing will not be because the other side is not here. Stopped. A hearing was made, issue was framed.
Hearing made,
What
issue
a-
was framed. What issue was framed?
Means that after the death of the tenant, whether the substitute.
Mr. Banerjee, opposite party was represented.
Represented.
So, have you not served upon them?
No, we have served. Notice was served and
Upon the landed advocates.
affidavit of service was.
No, no, after that, for mentioning for extension, did you
Yes,
serve
yes,
them
yes,
notice?
yes, we have served. My lord, 2 notices we have served.
Mr.
For
Banerjee,
extension.
landed advocate
These are
appears
the
for the
notices.
petitioner. He
Point. 7-1. Lord, 7 was filed beyond time.
motion, it was directed to appear under the heading contested application. 17 also same.
17 also.
17 same order. Next.
Lordship, in item 18, I beg to appear online. This is my lord for extension of my lord's interim order dated June 12, 2025.
Yes.
My lord,
The opposite party led by Lord Advocate Uday Narayan Mehta.
my lord, the
The
order was still
extended. The interim order is extended after hearing the learned advocates for the respective parties. The interim order is extended till the end of the month of February 2026 or until further orders, whichever is earlier. Contested application after 12 weeks.
and did you like
My lord, I may file my lord affidavit in opposition.
Civil division application unheard of. Yes, next.
Grateful, my lord.
obliged, my lord.
Yes.
My lord, I appear for the petitioner.
Yes.
On
Of the opposite party.
May 2025, my lord, an interim order was passed, which was subsequently extended on 30th of July 2025.
Yes, you are opposing. You are opposing.
They were present on both occasions, my lord. Both the orders were passed in their presence. The first order was also.
Now
passed
they are
in their
opposing. 4 days before the vacation. The interim order, the
Twenty.
20, yes.
I am appearing for the petitioner.
Extension of interim order.
Extension.
Service done. Every service taken on record. Mr. Mitchell, learned advocate, appearing for the petition submits.
You are for the petitioner visa.
You are appearing.
From time to file the reply, my lord.
Yes, it is appearing under the heading motion.
Extension of interim order is in the monthly list and item number 130.
It is appearing under the heading motion.
No, your lordship is contested application. Today it's extension of interim order.
No, it is appearing under the heading contested application.
No, today it is extension of interim order, your lordship.
Yes. It is extension of interim order. It is appearing under what heading?
Contested application, your lordship, because it was admitted by your lordship by an order
All right.
dated 16 January.
This
And one injunctions, your lordship, we want to file an supplementary affidavit as there are subsequent developments as they have filed another application.
the prayer of the learned advocate for the
application, if I could.
What? Civil division application.
There are some facts that, my lord, I need to put on record, my lord.
That's what documents were before the learned arbitrator. You can produce that. For that, you need not file any opposition, and they cannot improve upon their case by making any statement in the civil division application.
But may I,
And coming after
may I mention one matter, my lord? Yesterday list number 4. Yesterday's list, my lord, item number 4. The matter has been heard before your lordship, and the lordship directed to approach before the trial court by filing appropriate applications on regard of the decision of the child. My lord, the order is not been uploaded till now, and the trial court is not accepting that also. I'm just.
Yes.
Item number 1 with 2.
For all the reasons as a yes, call the list.
Item number 22.
হ্যাঁ স্যার আমি বাংলায় বলছি ভাস্কর মান্না বাবু অ্যাডভোকেট ছিলেন না, ওই ইম্পার্সন দিয়ে আমি ফাইল করেছিলাম। পরবর্তীকালে উনি আসছেন, উনি আসা আমার সিনিয়র উনি আসছেন, তারপর আমি পাওয়ার দিয়ে সেটা কি করতে পারি, হিয়ারিং উনি করবেন। আর যদি উনি হিয়ারিং না করেন, আমাকে যদি বাংলায় বলেন আমি বাংলায় তাহলে বলে দিচ্ছি, ইংলিশ বাংলায় মিশ্রিত।
What do you want? Do you want to move this, or you want to, or you want Mr. Manna to move?
মান্নার পাওয়ার নেই, আমারই পাওয়ার আছে, আমি অ্যাডভোকেট প্লাস ক্লায়েন্ট।
That's your choice whether you will move or Mr. Manna will move.
মান্না দিতে হলে তাহলে টাইম ক্লিয়ার করতে হবে সোমবার, তাহলে নেক্সট
On the prayer of the learned advocate for the petitioner.
My lord, I am for the plaintiff petitioner. My lord, this revisional application has been preferred against the order rejecting my application for amendment. My lord, I
Rejecting your application for amendment.
I am the plain, my lord, and that too, my lord, I want to incorporate that during pendency of the suit, I got possession of two rooms to an execution proceeding. And my lord,
That was rejected.
that has been rejected. My lord,
Reasonable requirement suit.
reasonable requirements.
Show me your amendment application.
On page 51 and 52.
there is substance in
Item number 24.
motion monthly subject.
I'm for the petition. I'm for the petition. But petitioner, interest of the petitioner has a plaintiff file a suit for eviction of the licensee against the opposite parties, dependent opposite parties. In that suit, my lord, they defendant file an application for repairing of the suit premises. My lord, they all
Eviction of a licensee,
Yes, my lord.
of a suit, of a room.
Of a room. My lord,
Where is the necessity for local inspection, Mr. Das?
my lord, no, my plain case is that the suit property is 100 square feet. The defendant claim the suit property is 250 square feet. Therefore, my lord,
There is no dispute with regard to the identification of the suit property.
therefore, the guise of the repairing.
The measurement is material in a suit for eviction of a licensee.
Infractuous, my lord, if they got the degree, I got the degree 100 square feet. Therefore, it can be executed by 100 square feet only. But you want to repair, my lord, 250 square feet.
Mr. Das, the shop room, there is a boundary. So there will be no difficulty in execution.
No, my lord, can you see the commissioner report?
Yes. Commissioner's report.
Yes.
Commissioner application has been rejected.
Commissioner application has been subsequently, my lord, allowed. Commissioner has been appointed, my lord, page 48, my lord.
No. Which order you are challenging?
I'm challenging that my application for the investigation.
22nd of July
Advocate commission was allowed. On that basis, my lord, the commissioner was appointed and commissioner filed a report. Thereafter, I made this application for the investigation commission for the measurement of the property. My lord, can you see the page 48?
Investigation commission for where is the earlier order allowing the application?
That is, my lord, page. My lord, the page 32.
No, page 32, it was not allowed. Hearing was fixed.
There, no, page 32, but their application for the amendment of the application for the appointment of the commission, it was rejected.
Amendment was rejected.
Challenging that order, they made a civil revision application before this honorable court. My lord, Justice Honorable Justice Sampa Sarkar was pleased to dispose of the revision application, directing that for the purpose of the repairing, measurement is not required. Therefore, the advocate commission appointed and filed a report. But that
is for the purpose of repairing.
That is for the purpose of repairing.
Yes.
I will see the page 48, the commission's report.
Yes.
See that the adjoining room is my room, landlord's room. He tried to occupy both the room, my lord. Left side, my lord, there is wooden door, two wooden door.
Yes.
And my lord, the eastern side, my lord's right side, there is broken wall, that is partition wall. Therefore, there is two rooms. One room occupied by the landlord, that is 150 square feet, and tenant occupied by the 100 square feet. Therefore, he tried to repairing the entire premises and grab the property. The plain case, page 17, the plain case is that is 100 square feet only. He has, in written statement, he has not filed any counterclaim or the schedule that the suit property is the 200 square feet. Written statement, nothing stated anything about this. How, my lord, the guise of the
Where
repairing?
is your application for legal inspection?
Yes, my lord. That is page 49.
Mr. Das, have you amended your plaint?
Amended, my lord, since the original plaintiff has died, thereafter, my lord.
Have you amended?
Yes, my lord.
Where is the amendment carried out? Show me the amended plaint.
My lord, the page 12.
Page 12 is the amended plaint. Show me this fact that you have said that during the time of repairing or so, this wall has broken down. Where is that fact you have incorporated?
No, what subsequently it has been broken down. His intention to grab the property.
Mr.
Otherwise, I could have.
Mr. Das, if you do not amend your plaint, how can local inspection is to aid the suit for the purpose of deciding the suit? If that is your case, you have to amend your plaint stating that fact. Only for that proving that fact, local inspection can be allowed. So you are proceeding with the earlier plaint, where it's the case that it's a 100 square feet room.
Yes.
So you have not made out this case.
At that point of time, he was not occupied. The premises
I
was.
appreciate, but it's a subsequent event. You cannot incorporate that subsequent event by way of an amendment. You will proceed with the earlier pleadings and you want local inspection for the subsequent fact. This cannot be the other way around. You will collect evidence, then amend your plaint. It has to be the roundabout way.
But then I have to take instruction when the suit plaint was amended. My lord, otherwise, my lord, the otherwise can you consider, my lord, the suit should be infructuous.
So you amend your plaint if your suit. That is why, unless you amend your
amendment made only, my lord, they have seized, my lord, the original plaintiff died. They are legally asserted.
Neither here nor there. That's a formal amendment. But here you are trying to make out a case. There was a partition wall between two rooms.
Yes.
You are on the northern side. They were on the southern side. So wall in between has broken down, or they have broken down. Yes, they have pulled out. So now they are trying to encroach upon your property of 100 square feet. Where is that case made out? This broken down, they are trying to make out this case you have not made out.
Those are done, my lord, subsequently, my lord. This is not the at the time of the filing the plaint. This was not there. My lord, can you consider?
Repairing application allowed or not?
Repairing application is not yet allowed, my lord, since, my lord, the application
But for the purpose of repairing, earlier local inspection was held. Commissioner submitted a report for repairing this local inspection.
Not against the repairing, but I am only repairing to the suit premises. What is the suit property? 100 square feet. This is the only submission, my lord. My lord, I am not against at all. Not I am against.
You have to bring on record those facts in your plaint. Unless you bring on record those facts.
My lord, when the suit was filed, my lord, that was not there. Therefore, my lord, by suit in the schedule, I have stated 100 square feet.
I appreciate that at that point of time it was 100 square feet. Now you are saying that wall has been broken down. So it's a bigger room now.
It is, my lord, it appears from the commissioner report that it's clearly stated that there was a wall, there is two, therefore there is.
Thus you are refusing to understand what I am saying. That's the difficulty.
Without investigation, commissioner, how the suit's property should be identified.
Please amend your plaint. Now you have come to know. Please amend your plaint. If you don't amend your plaint, those facts are not brought in. Why local inspection?
Well, he should be preserved that what 100, plain case is 100 square
This-
feet.
What do you want? If you want adjournment, I can give you adjournment, or if you want to move on this, choice is yours. Whether the suit room is 100 square feet or 250 square feet, that's collection of evidence.
I have to take instruction of why, my lord, the
After some argument, the learned advocate appearing for the petition submits that he wants to take instructions in this matter. So we list this matter.
My lord, kindly pass over the matter for 30 minutes. As senior is on the way. Madam.
Who is your senior?
Pradeep Kumar Paul.
So you are the advocate on record.
Yes, sir. I am the
You
advocate.
can start. Your senior will join you.
No, sir, he is on the way. And
What is the order impugned?
it is a prayer for expeditious here.
Expeditious hearing.
disposal.
You move the prayer for expeditious hearing.
No, sir.
Expeditious hearing order will not be
My lord,
passed
kindly
in
allowed.
presence of the senior.
Kindly allowed, my lord.
Expeditious hearing of what?
He is on the way.
Sir, have you gone through the brief? Have you read the brief? You have not read the brief. Go through the brief. Do you have a copy of the brief? Yes, I am passing it over after 10 minutes. I will not allow your senior to move.
My lord.
Yes, I am giving 10 minutes. Please go through the brief. এটা 10 মিনিট পরে ডাকবেন। Yes, call the next matter.
Item number 26.
My lord, I am for the petition. Plenty before your lordship, suit for partition and permanent injunction, lordship expeditious disposal, lordship till date, my lord, order 39 rule 1 and 2 has not been disposed of.
You are the plaintiff.
Yes.
Have you filed your amended plaint?
Yes, lordship.
When?
Lordship, last occasion I have filed, that is not recorded, my lord. Last order is of
Last occasion means it has been fixed for filing on 22nd of September 2025.
by put up application I filed.
You have filed.
Yes.
So what's the next date fixed?
22/9/2025.
Injunction application is still pending.
Yes, lordship, kindly see.
Any
Injunction order be extended till next date.
They have appeared.
They appear, filed WSW, everything.
Written objection filed.
Yes.
All the defendants have appeared.
All the defendants. Some of the defendant against ex parte order was recorded.
Under Article 227 of the Constitution of
I am for the petition.
Yes, Mr. Kaur.
Lord, this is a peculiar situation, Lord. Indian Medical Association, Lord, has a Bengal branch. There was an election held there.
I think I had dealt with this matter in the division bench.
No, I'll tell you.
No,
Lord.
that was the cardiological.
That was different. Now, Lord, what happened here is very unfortunate. Lord, the person agreed, Lord, he preferred, Lord, an application before the election tribunal, which is, Lord, constituted in Delhi. Now, Lord, the election
Cor, what is happening? All these associations, election
it's impossible. And Lord, what has happened now is that, Lord, election tribunal disposed of, Lord, the matter, adjudicated, disposed of.
What was the dispute?
Dispute was that with regard to a person being elected as the election commission and 2 members being elected as the part of the election commission.
So the constitution of the election commission was under challenge.
Was under challenge by one of the contesting parties. By one of the contesting party who may have lost. Now, Lord, whatever it is, Lord, the merit of the matter is not required. Lord, the tribunal disposed of the matter by adjudicating the matter. Now, Lord, a suit is filed in the Alipur court. Your Lordship kindly sees the plaint at page 18. Lord, the only defendant is the tribunal. Lord, the person who applied before the tribunal, Lord, he has not been made a party. Kindly see the defendant. Election Tribunal of India, represented by, they are the members of the tribunal who has passed the order.
Relief claimed is?
Kindly have a look at the relief claimed, which is at page 28. No personal allegation.
Which page number is the? One is.
The printed copy. Printed. এগুলো কাটোনি কেন? এগুলো কাটা উচিত. We kindly come to page 28.
Yes, sir. Declaration that the
director. Sorry. 38. I am sorry.
No, I've got the prayers of the
yes. Declaration that direction from order passed by the defendant's national tribunal is illegal, not binding upon the plaintiff. Declaration defendants have illegally adjudicated disputes, etc. Now, Lord, this is on merits of the matter, not no personal allegation against.
Now, what is the impugned order?
Lord, I have applied on behalf of the tribunal. I made an application under Order 1, Rule 10, Sub Rule 2. That please delete the name of the tribunal. Because, Lord, the person who had applied, he has not been implemented as a defendant in the suit. Now, Lord, the learned judge, kindly see the order, Lord, page 70, is treating the application as a, Lord, adversarial litigation and, Lord, then, Lord, fixing.
Oh, Mr. Kaur, only this is the order under 8th of September 2025 is under challenge.
That is, Lord, preponing. Before that, just the order before that, 25th of August 2025.
Yes, fixed 19th of January for hearing of the Lord. So now you want preponement.
Yes, Lord. I want, Lord, either, Lord, we should be allowed to go. The tribunal should be allowed to go. Why should the tribunal not? There is a Supreme Court judgment.
Mr. Kaur, I appreciate that, but how can I prepone a date, Mr. Kaur?
Lord, kindly, Lord, I just want, Lord, kindly, Lord, delete the name here. I don't mind, Lord, giving a notice to the other side. Lord,
Mr. Kaur, that would be amounting to dismissal of the suit because you are the only defendant.
The other contesting defendant has applied for being added as a party.
I appreciate that, but cannot be done here. Cannot be done here because you have seen the recent decision authored by Justice Bagchi.
Yes.
So this cannot be done directly here. It will be amounting to dismissal or because if I dismiss it from here, assuming expunging means dismissal of the suit if there is no defendant. So can it be done here?
Lord, may I serve a copy and come back in November? Your Lordship, kindly consider this. Lord, there is a judgment of the Supreme Court, the 3 judges bench, which has clearly held that in an adjudicative process, a tribunal or an administrative body even can't be made a party.
No, I appreciate that. But for that, you have to make that submission there.
Lord, I have made that application. Lord, the court is not inclined to hear it. Court is considering it to be an adversarial litigation. Court is directing that plaintiff should file an objection and all that process. Lord, does it need any objection? Reading of the plaint. If there was a personal allegation of bias, there is a personal allegation of any overt act on the part of any of the members, I can understand. If this is not indulged, then tomorrow
can do one thing.
Yes,
I can direct the learned judge to fix an early date of hearing.
Kindly do
but
that.
I cannot fix it from here.
Kindly do that, Lord. Kindly do that, Lord. I want, Lord, the tribunal should be relieved of the proceedings. This is an unique, Lord, way of harassing the members of the tribunal, which is, Lord, absolutely unprecedented.
This application. Yes.
My lord, I am for the petitioner, my lord.
Yes.
This is an application for disposal of early disposal of a matter which is pending in OS number 6 of 2017 before the fourth bench Barasat, my lord. It's
So it
almost
is what stage?
My lord, every pleadings are complete, cross-examination are complete, the application order 18 rules.
Cross-examination of all the witnesses completed.
Only one, my lord. Yeah, everything is complete, my lord. Everything is
No,
complete.
I could not follow. Whose cross-examination has been completed?
My lord.
Whose cross-examination has been completed?
My lord, defendant and everybody's cross.
Now, what is the next date fixed? For what?
My lord, 17th of January 2026, my lord.
For what?
For evidence, my lord.
No, you are saying the evidence is completed, then why evidence?
My lord, they have made an application of Order 18, Rule 17, my
So
lord.
recalling of witness.
That has also been rejected, my lord. That has also been rejected, my lord. The
Then
only
what is
thing-
the next date fixed then?
17th of January, my lord, 2026.
For what?
For evidence, my lord, for evidence. I have entered the entire order
Sir,
sheet.
I could not follow this. If the evidence of all the witnesses has been completed, an application for recalling of the witness that has been rejected, yeah, it will be fixed for evidence. I cannot understand that. That's the difficulty.
My lord, only is that these are two petitioners, my lord, who are 78 and 75 years old.
Sir,
And they are
that's
ailing, my lord.
material, sir. I am asking you because the order sheet says it's for evidence, and you are saying all the evidence has been completed.
Order sheet last.
This
my-
application under Article 227. Yes.
I am for the petition, my lord.
Yes, yes.
In a suit for partition, I made an application under Order 1, Rule 10(2) for striking out the name of the defendant. That has been rejected, my lord. My lord, plaintiff in a suit.
Who are you?
I am the defendant. Defendant number 1 to 3, lordship. Actually, this property, the suit property is a Devottar property, and the plaintiff has filed the suit for partition of the joint property, suppressing the fact this is a Devottar property. Now, my lord, the plaintiff claimed to be has inherited the property from Narayan Chandra Nondi. The Narayan Chandra Nondi father, who declared the property as a Devottar property, and thereafter, on the demise of the Narayan Nondi, his father of Narayan Nondi, the Narayan Nondi sold the property.
According to you, it's a Devottar property.
Yes, my lord, there is a decree on this issue, my lord, on the lordship. If your lordship kindly come to.
So you can raise that issue at the time of trial.
My lord, that is the order the learned trial court has passed.
You can
No, my lord,
not
my lord.
appear in the suit.
My lord, kindly consider the decree, the judgment which was passed in the year 1975, more than 30 years old, my lord. And
You
then
can refer to that. You can refer to that. The suit will be dismissed for that.
This is a fruitless exercise, my lord, because the plaintiff who is claiming the property by inheritance from his father sold the property some outsider. In the said suit, his father deposed at PW1, and that suit was dismissed. That is at page 37, my lord. I have annexed the certified copy of the decree, my lord, of the judgment, and that judgment was challenged, which was upheld in the appellate court as well as before this honorable court, my lord. Now, if the property is a Devottar property, there cannot be a partition of the Devottar property. And the suit has been filed in our.
Where is your application? Where is your application?
My lord, my application is at page 114, my lord. I have stated everything, my lord. Because under section 79 of the Evidence Act, there is a presumption the genuineness of the certified copy, my lord.
Sir, yes. So you produce those documents.
Yes, I have submitted before the learned court, but the learned court directed that matter to be ended by adducing evidence. But if the certified copy is there, which is a genuine document, more
Not
than
at
30
the
years.
stage of order 1 rule 10, that cannot be done.
My lord,
This
before that, I have also filed the order 7 rule 11. That too has been rejected, my lord. That I have also stated.
Have you
my lord.
challenged that order? You have not challenged rule 11.
My lord, that I have not challenged. But since this is in a personal capacity, but admittedly,
Alright, that can be decided only at the time of final hearing. This
Then, my lord,
suit will be dismissed then.
Yes, my lord, should it be? That is why my submission is that will be a fruitless exercise, my lord.
This application
And
under
this
article,
matter will be dragged,
this
my lord.
application under article Yes. None appears for the petitioner at the time. This is for defaultings.
Order number 32.
So this is my application,
Yes,
Lord.
sir.
The matrimonial suit was filed seeking declaration for nullity of the marriage. And my lord, the written statement was filed. After that, chief also filed. And order 12 rule 6 application was filed, but that had been rejected.
Why order 12 rule 6?
Because my lord, whether the marriage was consummated or not, that was the only point. My lord, both parties admitted this fact. My lord, and I am relying upon
Where is that? Where is the admission?
my lord, kindly para 7 of the WS at page 17.
Paragraph 7.
Paragraph 7 of WS, page 17. And my lord, page 23, the chief filed by the husband at page 23, paragraph 4.
Where is your plaint?
My lord, plain as my lord, page 11 at para 4. And lastly, my lord, I am
You
relying
have a copy of this. This is a special marriage act.
my lord.
You have a copy special marriage act.
And my lord, lastly, I am relying upon one order where your lordship appeared.
I appeared.
Yes. Yes, yes.
It's binding upon me.
No.
One. It is not an admission, Mr. Dolopati. Admission has to be clear, unambiguous. 25(3) is a different thing altogether. 25(1) is a different thing altogether.
Look,
There
25.
is not, yes, 25(1) says marriage has not been consummated. Owing to the, no, not only that, you cannot stop there. Owing to the willful refusal of the respondent to consummate that marriage. No, kindly come to paragraph
Kindly
17.
come to the
Paragraph 17.
17.
Yes.
Paragraph, page 17.
Page 17, paragraph 7. You have placed that.
Yes.
I'm at that.
Yes.
So that is not an admission to that effect. Please,
Yes, the marriage related such and such was not consummated in between the respondent and husband and the petitioner wife, and moreover, the respondent husband and petitioner wife did not share the bed to each other with the expectation that marriage to be consummated.
Yes,
They will be
it's not
ready to
refusal. Both of them decided. That's the case made out. So it is not agreement. Judgment on admission cannot be passed, Mr. Dalapati, on
Kindly come
this.
to page 23. In his chief, page 23.
Evidence has been completed.
Yes, chief file.
Chief filed.
Paragraph
Yes.
4, my lord. That I say that I patiently tried to convince my wife or petitioner
That is the husband's statement.
Yes.
The husband's statement. So
I am
admission.
for the wife. I am for the wife.
You are for the wife.
Yes. Husband refused me.
There is no admission because both are not at idem. You are saying another thing, he is saying another thing. It's not admission. You can get a decree of nullity on a contested hearing, not on judgment on admission. Admission is both the parties have to say the same fact. Your specific case is otherwise. It's not refusal.
Yes, my lord, refusal. But the husband have some reason. But in disguise it is refused.
No.
Your lordship is telling me unequivocal.
Yes, has to be. Those are the line of decisions. Mr. Dalapati, it's difficult to don't rely upon the matters in which
Your
I am.
lordship appear before justice.
Yes.
Same thing.
That is why I'm telling you, don't because I know those.
And Milord,
these are the
original fact is, Milord, both parties are agreeable and both parties waited for 1 year to pass the order. After 1 year, Milord, this order was passed.
That is mutual consent divorce. That is mutual consent divorce. Nullity and divorce cannot go together.
My lord,
if nullity is there, divorce on mutual consent.
Section
Then
20.
you have to accept the marriage. Then you can go for. That's a different thing altogether.
I know, Milord, your lordship
One
have
thing.
vast knowledge, but one thing which I understand, Milord, section 25 Roman 1 says, until or unless, if the marriage is not consummated at all, then the marriage to be nullity.
Owing to the refusal of the other side.
Refusal, Milord.
Yes, here it's not refusal. Written statement is the other way around. It's a conditional. Both the parties agreed with some. I cannot tell it every time because now we are live streaming. এই এটা বন্ধ করুন live streaming টা বন্ধ করতে হবে।
Live streaming টা বন্ধ করুন।
That is number 33. 33, I am for the petitioner, my lord.
Yes.
No, dependent is the petitioner before your lordship.
What is the order impugned?
Expeditious disposal, my lord.
Expeditious disposal.
My lord,
What is the
second,
stage of the suit?
no injunction application has been, my lord.
Injunction
Final,
pending.
yes, my lord. Final hearing and
This
as well
application
as
under
order
Article
39 rule
227 of item. Huh? Oh. Yes.
Lord, I'm for the petitioner. Madam, I'm filing this application for early disposal.
Yes. Early disposal of what?
Title suit being number 17 of 21.
Yes. What is the stage of the suit?
The stage of suit, it is still in the for the appearance of the performer defendant.
Appearance of the pro forma defendant.
Yes.
Service returns. How long you are practicing?
4 years.
4 years. Ashun. Yes.
Well, I'm playing for a passover.
Why?
Well,
No
the conducting
Passover.
advocate is in courtroom number 35.
Start. What is this matter?
Well, a short passover, my lord. Kindly.
What is this matter? Expeditious hearing. This application under Article 220. Five. For Mr. Shoptanshu Basu or any of his juniors to come.
Now, I'm informed.
Lord, I am for the plaintiff petitioner.
Yes.
Lord, this suit for Miller's partition and injunction, Lord.
Yes, what is the impugned order?
Impugned order, my lord. Lord, so kindly come to.
What is the order impugned?
21, Lord, so kindly come to page 21. Order dated 14/8/2025.
14/8/2025.
Learned advocate for the plaintiff submits that that right order dated such and such. Predecessor in office has directed the defendant number 1 to remove one wall from the suit property within 15 days from the service of notice, and also directed the plaintiff to furnish intimation to the defendant number 1 about the said order. In compliance with the said order, the plaintiff have already intimated the defendant number 1 about the said order. But the defendant number 1 did not comply with the said order. Hence, the instant application has been filed by the plaintiff praying for passing necessary order for removal of the said wall. Upon peruse of the case record, it appears that plaintiff have filed the present partisan suit against the defendant and got an ad interim order of injunction in the form of status quo, which was
Yes, your case is that of violation of an order.
Lordship.
You file an appropriate application for that. File an application for that. A miscellaneous case has to be filed. The learned trial judge has said that could have taken appropriate steps as provided against the defendants.
No, my lord, but subsequent order is that, my lord, your lordship, kindly come to my lord last portion of the order.
Yes.
Therefore, at this stage, this is no such material on record wherefrom it can be found that the defendant intentionally disobeyed the direction of the honorable court and did not remove the wall. Besides, as per prayer of the plaintiff, the local PS has been directed to ensure the due implementation.
All right, you file an appropriate application that will be considered without being swayed by the observations.
Well, in this order, my lord, it was hold that, my lord, no offense was.
This order, there is no infirmity because violation cannot be proved in that manner. This application under Article 227 of the Constitution of India is at the instance of the
Lordship, I beg to appear for the petitioner. This is application for expedient disposal of title suit number 495 of 2025-24, which is pending before second bench of City Civil Court. The suit is for seeking for declaration and recovery of khas possession and main profit against the opposite party.
Under Article 227 of next matter.
Matter number 37.
My lord, I am for the petitioner. The matter is for expeditious disposal.
Of what?
My lord, there are two suits. One suit is filed by me for eviction and for my lord recovery of possession against the defendant, my lord, in respect of the suit property.
No, no, in this you have filed for expeditious hearing of title suit number 78 of 2022.
Yes, my lord. But my lord, during the pendency of my suit, my lord, the defendant in my suit, they have also filed a suit. My
That cannot be decided here.
No.
For that, you have to file a separate application. This application under Article, what is the stage of the suit?
My lord, as the landed court has passed an order for my lord status quo in the suit filed by my defendant, my lord. For that reason, my lord, I have my suit has not been proceeded.
And what happened to the Section 10 application?
My lord, both the matters is the suit in my suit, my lord, is also directly at my lord substantially in issue with the.
Sir, what happened to the Section 10 application? I am asking you.
Section 10 is still pending, my lord.
Pending. What is the next date fixed in the Section 10 application?
My lord, the last day was the date fixed, my lord, and my lord, the next date has not been.
What is the last date?
My lord,
Yes, Mr. Basu, I've given you trouble to hand over the book personally to you. Otherwise,
This is too much. This is too much.
You will not blame me afterwards.
My lord cannot save by this way. There are other cause of action will come to blame.
No, Mr. Basu, because this book is here, that is why I told.
No, I get. Whenever it is with the officers, I could get it. No problem.
No, because the book, if one part is somehow misplaced, I know what has happened. That is why.
So I am concerned. The problem is in top there is notings.
That is
Book
why
we can get, but noting.
That is why on that date I asked you to keep the book, but from that day itself it started troubling me.
Grateful to my lord.
Sorry for
my lord
giving.
think this.
No, sorry for giving you trouble for bringing you here.
But my lord, think in this way. I am grateful.
Yes.
My lord, the next date is 21st January 2026.
For hearing of this Section 10 application.
Yes, sir.
This application under Article 227 of the Constitution of Yes.
Item 38.
Well, I'm for the petitioner.
Yes.
I'm for the opposite party, my lord. It's not been served on us. It's a 227, so I.
Not being served.
No, my lord. Well, I do not know
Yes,
whether any
because why
caveat
was
is
it
being-
served?
They've given a notice, my lord. No caveat, but they've given a notice that they're going to, my lord, move the matter today.
You can give a notice, Mr. Mukherjee, but you cannot serve a copy.
This notice informs us, my lord, that there's an application CO 3507
This
against
has
the
been
order,
notified before the
and
land
that
arbitrator.
and that they'll pray for an adjournment in the arbitration.
This
An
has
order of the arbitral tribunal, which is challenged in a 227 petition. So I'm without even looking into the papers, but I'll take up a point of maintainability.
I am ready
It's
to
not
answer
that this is a section
I'm ready
16
to answer
order or
that.
anything.
I'm ready to answer
It's
that.
an order passed
Then my lord
by
is
the
ready
arbitral
with
tribunal.
similar hearing.
Yes, on the point of maintainability, definitely I am.
Yes, yes.
Without looking into the papers, this is not maintainable. That's what I'll argue, Milord.
Milord, the SBP Patil, Milord, 2006 Supreme Court is of
No,
the
what is the
what is
what is
Milord,
the order impugned?
initial order permitting him to file Milord, the claim, Milord, the statement of claim within a particular time. That lapse. Again, he prayed for an extension. Once extension granted.
Claim petition.
Claim petition. Once extension is granted. That extension, not the extended period, again lapsed. I filed an application under section 25 stating that in view of section 23(1) non-compliance, kindly terminate the proceeding. After my application, after about lapse of 1 month, they filed the application. They filed the statement of claim without even filing any application for condonation of that period, which they admittedly in default, without any application. Now, my section 25 application was taken up by the learned arbitrator and by the order impugned without any application for them for prayer for condonation of delay, allowed his statement of claim to be on board. I say, Milord, it's in view of section 23(4) of the Arbitration and Conciliation Act, it's barred.
We have relied on a judgment of this honorable court.
Lord, I'm ready also with that.
Then Mr. Mukherjee, give him a copy
Yes,
because
definitely. Only one thing, Milord, I know, Milord, now the pressure. Milord, 26th is the date fixed before the learned
Arbitration. Arbitration has to, Milord, they can't pray for a stay of the arbitration proceeding.
I'm not praying, Milord, let the learned
Because of section 5.
the
Kindly
entire
take up-
issue is whether the mandate got terminated or not.
It can't
That's
be.
the entire issue.
No, they have not filed under 32. Kindly see section 25. They
25,
say the
yes.
petition is under section 25. Under 32, they could have, Milord, state that this is a termination of. That's not the case. The case is that you close the statement
Consider
of
that,
defense.
Mr. Bag, you cannot proceed with the arbitration.
Kindly don't kindly hear me out. Any day, Milord, kindly do not pass an order of stay of the proceeding. Milord, the arbitration will come to a standstill, Milord. That's their aim. That's what they have aimed for. Interestingly, Milord, I tell you,
who has defaulted in
I tell you, Lordship, what they've done. They have not filed. They have not.
I appreciate
My lord.
that that's their aim.
Not
Now,
filed an application for.
when the arbitrator was appointed, when you filed the claim application, show me your diligence.
We will, Milord.
Show me your diligence. Give me the states. Kindly, the arbitrator was appointed, and when you filed the claim
That's
application.
all there, Milord, in the order impugned. Where is the order?
Yes.
impugned? Give me the order at least. So kindly keep
Because
it
as
any.
I've heard, if those facts are not in dispute, so that's
Kindly take up. I'll indicate by
landed arbitrator, Mr. Bag, whether you are entitled to file or not, that's the matter which I will consider.
Lordship.
But don't say that you are diligent, they are trying to stall.
But I'll indicate why. I made this submission. But once we file the statement of claim, they should have come up with a statement of defense.
After lapse of how many months?
Not a lapse of, they have, it's a delay of around 14 days from the last extension that was granted.
Why did you pray for extension? Is it a matter of course, Mr. Bag?
We had prayed, we had given a reason. Medical emergency, we had indicated
Yes.
that.
So you could wait for that.
We had indicated that, Milord. In the petition, Milord, we had indicated that was considered by the learned arbitrator. We had, Milord, then placed a decision of this honorable court, which has not been challenged, Milord. Coordinate bench, where, Milord, it has been held. What is the premise of section 29? What they have stated, Milord, 25 is what they have prayed their, Milord, petition for. Kindly take up section 25. I'll indicate my submission. Today, Milord.
Ready, Mr. Bag,
Yes,
with the matter, I can.
don't know what the papers are, Milord.
So,
That's the only difficulty.
He don't have any right of it.
He has given us notice that he has
not given
Bag, that's neither here nor there.
Indeed,
But since you do not have any lodged any
May only pray for
you
this.
do not have any
May only
right
pray
of
for-
audience also.
Indeed, Milord, may only pray for this. 26 is the matter, Milord. May it be taken up on Tuesday, Wednesday, any day that suits
I'm
you,
keeping
Lordship.
it, yes. I'm
Milord,
keeping
we'll come
I'm
back. We'll come back and we'll
directing this
indicate the
matter,
judgments.
Ashun.
I understand the difficulty. Where it's not taken up, then the arbitration proceeding gets stalled. They don't file a written.
No, if you do not oppose, I will not pass any order of stay.
I'm not opposing.
Yes. আসুন তাহলে ওটাকে স্টেট
Any date that your lordship is pleased to fix the matter?
if returning its position in the list, it will be retained.
Monday, I'm in some difficulty, my lord. That's the reason I'm praying for this.
Now you are saying you are
Only one day, my lord. Monday, I'm not there. That is
because let it retain its position because fixing a date will be a problem. It will go down.
I'm not opposing anything.
If you have any difficulty, you can pay.
Only one day, my lord. Monday, if I'm not there, my lord, my learned
Mr.
junior.
Park, now it's if a date is to be fixed, it will go down.
No, I
Then on
understand.
Tuesday, it cannot also be taken up.
Very well, my lord. I'm very deeply obliged, my lord.
Thank you. Yes.
But I appeal for the petitioner, my lord.
Yes,
But this is more in the nature of a sympathetic prayer, my lord. Non-commercial, but non-commercial suit. Written statement filed on the 122nd day, my lord. It was ready on the 120th day, my lord. I've given a time petition. The authorized signatory, my lord, due to family emergency was not there.
But the Honorable Supreme Court has said it cannot be.
I have a recent judgment, my lord, where Kailash versus Nanko has been considered, and my lord, in a non-commercial suit, my lord, it has been held. It's merely a
non-commercial.
Non-commercial, my lord.
Not a commercial.
He said sympathetic, my lord. Otherwise, I wouldn't have.
No, I was under the impression it's commercial.
I wouldn't have troubled the lordship only there. Non-commercial.
That was I was under the wrong impression.
But
I was under the impression it's a commercial.
I wouldn't have troubled your lordship at that way.
Show me the
Yes, my lord will kindly seize the certified copies, my lord. My lord, kindly seize the order dated 8 July, my lord. Certified copy, my lord, 8 July 25, my lord.
Yes. No, show me the impugned order.
Yes, my lord, the impugned order is, my lord, kindly bear with me for 2 minutes, my lord. But 8th of August 2025, if your lordship sees the order dated 8 July, 8th of August was the last chance to file the WS. My lord, on 8th of August, my lord, I filed a time petition, which is at page 38. I have said that the written statement is ready, but the authorized signatory could not be made available. But the matter was adjourned to 29th of August. My lord, on 11th of August, I give a put-up petition and I filed the written statement, which was taken on record. But on 29th August, my lord, kindly seize the impugned order. The learned court below, my lord, was of the view that the statutory period is over, the written statement cannot be accepted. My time petition, my lord, is at page 38. The reasons for not filing on 8th of August is also given, my lord. And I gave up by the order.
Item number 40.
Yes. Not suit for eviction of a trespasser, treating me as a trespasser. Milord,
Oh, you are not a trespasser.
Milord, kindly takes up, Milord.
Mr. Mukherjee, you are not a trespasser.
Why, Milord, I say, Milord, the acquisition of title is.
Order 6 to 17 rejected.
Yes.
Your order 6 to 17.
My written statement, I have taken a specific plea that it is a Thika property.
Argument stage.
What it's a subsequent. I shall come back, Lord. I shall show before the Lord. I shall come back, Lord.
What is the subsequent stage?
Subsequent stage
You are
because
hungry, Mr. Mukherjee.
little.
Or you are trying to
No,
take
no, no.
some benefit of
Then I at 2 p.m. we will have to come. I cannot, Milord. Milord, there here, Milord. Why I say subsequent stage? Subsequently, Milord, the proceeding has been initiated before the Thika controller, which has not been still settled. I made an RTI. Thika controller said it's under adjudication till date. I want to insert that fact. Why? I will also explain before your lordship. Until and unless I insert this fact, I will not be permitted to move an application for stay of section 10 also. Because I have challenged by virtue of the deeds by which the plaintiff have acquired title. If it is a Thika property under 2000 Act, it cannot be transferred. This particular sale deed, challenge to the sale deed is pending consideration before the Thika controller. I have annexed that RTI also. Section 6. The reply, page 38.
What is your reasoning for the delay?
I say, this is of 2024 communication from the Thika controller, which I want
And
to.
can you file this application?
This application.
Yes, for amendment.
না না অ্যাপ্লিকেশনটা কবে ফাইল করে সেটা বলুন না, চেঞ্জ ব্রিফ বলে কি হবে? Exact date, my lord, I have to check because in the application it has not been mentioned. Yes, yes, my lord, it's July 2025.
Come after having your lunch. 2 p.m.
Matter, because now it's got on filing, but yeah.
Please use the microphone.
My lordship, I only can take one leave for this matter. The filing has been refused to take.
Why?
This is put up petition has been filed.
So why filing has been refused?
They told that we cannot take the leave from the court.
No, why? What ground filing was refused?
This is challenging that the put up petition is rejected by the lower court.
Yes.
That's why the CO is filing. That's why they are telling in the file.
You have not filed any certified copy of the order.
No, no.
Have you filed the server copy of the order?
Put up petition only rejected, my lord.
Without the order cannot be filed. No. Yes. Supplementary stuff afternoon?
But if your lordship take up my written statement once,
Yes.
but at page 19 of my lord's brief, I will only invite your lordship.
Please give me the plaint.
Yes, my lord. Plaint starts at Lord page 13 of my lord's brief. The kindly takes up paragraph 2. Haidar Ali is my father. Has your lordship got?
Yes.
The plaintiff is stressing title by virtue of the successive transfer which has been taken place from Haidar Ali. Haidar Ali is alleged to have been sold in 2009 to such and such person, my lord, as mentioned Roman 1 and Roman 2 at paragraph 2 of the plaint. Thereafter, your lordship will get paragraph 3. From them, the plaintiff is claiming title through a subsequent transfer of 2nd of September 2011.
Yes.
Has your lordship got it, my lord?
Yes.
According to the plaintiff, after this two transfer is being made, I being the heirs of the Haidar, I don't have any right title interest remain to remain in the property. So my possession has become a possession of a trespasser. So the suit for eviction. This is the conspectus. Kindly takes up, my lord, my written statement once. My lord, that is at page 19 of my lord's brief. Kindly takes up paragraph 20, my lord, page 20, paragraph 10. I will not trouble your lordship. Kindly, my lord, takes up Roman A to Roman D. So my case is that not your lordship knows after 2001, even a thika tenant do not have any right to sold the property in question in favor of any third party. Prior to promulgation of 2001, this was permissible with the permission of the thika controller, prior permission. Now 2001 Act, there is a bar of transfer. Now, my lord, kindly takes up page 26. My lord, my positive averment is paragraph 10. Thereafter, my lord, denial, my lord, I am not troubling. যে ডেটটা দেখাচ্ছিলেন আমাকে
Yes. Now show me your application.
Before the thika controller, my lord, page 26 of my lord brief.
No, show me your amendment application.
Amendment application is at page 40 of my lord's brief. The schedule of amendment starts at page 43. Some portion is reiteration in the first plot 13 small a, which has been inserted. My lord, kindly turns over the page, and page 44 is important.
Yes. This pendency of two miscellaneous cases.
It's miscellaneous. It's miscellaneous case number 1. Dated is not 23rd of June 2020, and it's miscase number 1 of 2012.
How can it be 2012 miscase dated?
No, because it's 2012. It's wrongly written. It ought to have been 2020. Page 26 of my lord's brief is
so this is a typographical error.
Yes, my lord, your lordship knows, my lord, the thika controller office or my lord, the rain controller office, they do not sat regularly. It's the application, thereafter it's registered.
No. So either this 23rd June is wrong.
No, my lord.
For one of
23rd June is correct. That's right. Yes. My application is, my lord, I have also annexed that.
Yes.
There, my lord, I have prayed specifically.
So you wanted to incorporate this fact
and my lord, why, my lord, I incorporate? My lord, may I take your lordship to my RTI reply, because they do not give any, my lord, regular, my lord, hearing order. So their order sheet, my lord, we get after, my lord, the final order is being passed.
Yes.
Page 38 kindly once looks at this. I got after the commencement of argument because I do not know what is the fate. I applied, page 37 is my application under RTI Act. I specifically wrote what is the status of my application. Kindly takes up page 38 is the answer.
Yes.
This fact I want to
This is status of
Yes. Of my
pending.
is still pending. This fact I want to incorporate because it will not change the nature and character of the suit. No de novo trial, nothing else is required. I say, my lord, my defense case also remains unaltered because I shown before your lordship paragraph 10 of my written statement. I am not really altering my any of the case, which does not even, my lord, allow, my lord, rather, my lord, trying to incorporate something which, my lord, in my lord, de novo trial is necessary for that.
Yes.
This is my submission.
This application under Article 227 of the Constitution Grateful. Yes, next. Supplementary.
Supplementary list, item 1.
Yes. Yes, Mr. Kormukar.
Yes, my lord.
What is the grave urgency?
The urgency is, my lord, the suit is basically for declaration and injunction, my lord, for stopping a Durga Puja to be held in my premises. I am the builder. A part of the construction has come up. A part is yet to come on the way of construction. Some of the persons who have got into the possession, my lord, have stopped paying their maintenance charges and
in the flat.
Yes.
Flat constructed.
Part constructed, part is to be constructed. Now, my lord, persons who have got possession of, some of the persons who have got possession have stopped paying the maintenance. And they are also restraining my persons, my lord, to get into the premises for construction of, my lord, the remaining part. In this situation, to establish, my lord, their hold, they are trying to conduct, my lord, no society is from nothing. The possession is also formally with me. I mean, in such a situation, they are conducting a Durga Puja in my premises without my permission. They are conducting a Durga Puja in aid with, my lord, certain third persons, my lord, outsiders, my lord, without my permission. My lord, that, my lord, for stoppage of that, I have filed this suit. I have moved an
I am trying to stop a Durga Puja. Mr. Kormukar, I am asking them to invite you in the Durga Puja also.
But the difficulty is, my lord, if this is
You want to take control over the fund.
not about the control. So, Lord, the problem is if this is permitted, Lord, then each
Will
and
not
every-
create any equity.
Lord,
I will mention that it will not create
the
any equity.
difficulty.
Mr. Kormukar, you are only the developer or a builder, whatever name called. You will ultimately construct and it will ultimately transfer to the intending flat owners.
Yes.
So they will, after that, they may continue with the Durga Puja. After all, why are you stopping the
But the
Durga Puja?
difficulties, Lord, the common areas, the garage spaces, everything is being, Lord, taken for, Lord, the
For a limited
thing.
period, Mr.
Lord,
Jockey.
today, if it is permitted, Lord, tomorrow I won't be in a position, Lord, to hand over these places to the Lord, they will say that here the Durga Puja used to happen. You cannot sell this. You cannot show this as common areas.
No, I will. What is the order impugned? Show me that.
But order impugned is not fixing. What has happened is I tried to move ad interim. Lord, they were on
You
KB.
tried to move ad interim for injuncting them from holding the Durga Puja. Yes.
Lord, they were on caveat. So, Lord, we had to serve. We served them. They came, filed an Order 7 Rule 11. This was in July. Thereafter, Lord, in Order 7 Rule 11 took some time for hearing. 8th of Lord.
Order 7 Rule 11 disposed of.
Yes. On September, it was disposed
Rejected.
of. 19th of September. Rejected.
Yes.
19th of September, Lord, today was fixed, Lord, for the date of hearing of the injunction application. Now, Lord, while disposing of the Order 7 Rule 11 on 8th of September, Lord, the posting of the next date of hearing has been fixed in the month of November. 10th of November.
No, today was fixed for what?
For injunction hearing. Kindly see comes to the orders, impugned orders. Rather, Lord, the list of orders.
Now, Mr. Kormukar, what can be done now? What do you want me to do now?
Fixed a date, Lord, for the hearing of the injunction application so that I can get myself heard out at least. Tomorrow, Monday, whenever. I will pray for tomorrow.
Mr. Kormukar, that's the
Fine.
difficulty because
Kindly
only
see-
4-5 days also left for the trial judge
This
before
will
the
take
vacation.
not even 5 minutes. Kindly seize the orders.
Kormukar, you are saying it will not take 5 minutes in your matter. There may be other pending urgent matters also. It's not that it's only the matter which the court has.
Lord, kindly seize the way the suit has proceeded. Lord, I did not come late to court. Lord, I did not come. If this is, Lord, this is how suits are conducted. Lord, all
Where are the parties?
Parties are in Barasat area. Lord, kindly comes to the certified
By directive to serve and come back, it will delay.
Everything will delay. They are served, they know. They are contesting the suit. It's not that, Lord, I am taking orders behind their back. Lord, kindly comes to the orders once first. 7th of July.
Where is your injunction application? Show me.
Injunction application, Lord, page 35.
Page 35.
My Lord. And prayer at page 48. Kindly, Lord, comes to page 48. And the problem is, if this Durga Puja is allowed, my access to the second phase is stopped. That's their only intention. The only intention is I'll not pay the maintenance amount. I'll not let you inside, get inside this phase 2. I'll stall the construction.
Mr. Kormukar, that is your ego that they are not paying the maintenance.
One is
Or that is-
maintenance. I am not bothered. They will suffer. It is not that the problem is
Maintenance is in our control now.
The problem is this is a RERA certified project. So the responsibility of maintaining till a formal handing over of association is done is upon me. So
Mr. Kormukar, there are difficulties both ways.
My
Even
lord.
there are difficulties both ways. Even if I direct you to serve and ask them to come,
Same
then
problem.
yes.
Same problem.
So I cannot fix a specific date from here, Mr. Kormukar. It is difficult because from here, fixing a particular date, I do not know the business of the court. I can only
But may I
request that
suggest
is
this?
second.
May I suggest this? Fixes the matter to be taken up on Monday upon notice to the other side with serving of this petition also. That will suffice. That will cause nobody's prejudice. The trial court lawyer is there.
Mr. Kormukar, even if I do that, they may come, let us assume. Then I cannot pass an order directly from here. Injunction. So I have to then, only 4 days or 3 days effective days will be left. So can I take it up on a particular date? It's difficult.
But given the conduct of the suit court, Lord, I think, Lord, my Lord should exercise, Lord, that
Mr.
power under
Kormukar,
227.
it's difficult. 2 or 3 days, or I can do one thing, Mr. Kormukar. I can protect you. I'm not disbelieving you. I'm saying yes. I'm not saying for a moment that you have delayed or you have tried to delay. I'm not saying that. I can protect your interest because the only difficulty is the shortage of time. If that was decided one way or the other, I could have taken up, could have fixed. So now, in any way, it has to go back.
The difficulty is if what my Lord is proposing to Lord pass
I
an
can
order,
only say
Lord passes that order, Lord, that will basically circumvent the Lord trial court, the appellate court, and my Lord will be passing. My Lord can, under 227, my Lord can pass that order. Tomorrow, my Lord, they will come up and say, Lord, we were not heard. My Lord has passed this order at an interim stage. We were on caveat. This will be the problem.
No,
So what I am
no.
suggesting, Your Lordship, is
I am saying that I will not be passing any orders for injunctions. I cannot do that from here.
Yes.
So I can only observe. If they do that, that will be, they cannot claim equity even if they perform Durga
my
Puja for
access
that.
to the second phase is getting stalled. They have already installed, my Lord, those bamboos, bamboos and my Lord, iron rods, made a pandal, my Lord. My access to the second phase is stalled. My project, fire safety hazards might come up. Entire RERA responsibility is upon me.
For that, Mr. Kormukar, I can give you can do that. Praying for a direction for removal of those immediately after that.
So that's exactly what my
Or you can also come up before the vacation bench immediately after the pujas if they do not remove. For that,
puja is held. If the puja is held and if some mishappening happens, I will be held the most responsible person under RERA, under fire, under everybody.
So I can,
Then, my Lord, nobody will come
I
to
can
protect
give
me.
you liberty to approach the learned trial judge for fixing a date. Fixing from here will be a very
Fixing
difficult.
the date on Monday, Lord, I shall put the other side on notice because they are appearing. Lord, I'll get a time tomorrow. Today also I'm getting that time. Saturday I'm getting that time. They are fixes at 2 p.m. Fixes at 3 p.m.
Where?
Lord, before the trial judge. Or whenever the trial judge fixes on Monday. Lord, else Lord, kindly comes to the orders
By which order
once
it
for
has
my
been-
satisfaction.
By which order it has been fixed in November?
Lord, kindly comes to the last
10th of November. 10th of November.
10th of
For
November.
151, dated second, where is that?
Now 151 is, my Lord, page 54. Kindly comes to the prayers, kindly sees.
This is the application which you wanted to move. No.
My
Unconditional apology.
Yes, that they have filed. I will
No,
tender
where is
apology.
your application? You said that it has been fixed on November.
35. No, 35, that has not been fixed.
Oh, your application has not been fixed. You said that it is fixed on 10th of November.
Next date is fixed on 10th of November.
All right. 10th, where is your application?
Yes, Lord, one thing I must show why I am saying today it was fixed. Else, Lord, that will create some problem. Lord, kindly comes to
order number 4, Lord, dated 20th of Lord August. No, that's in the certified copies only.
10th,
The last paragraph of that.
20th of August.
20th of August.
Yes.
Such and such both.
For injunction.
Yes, to date 19th of September. So it was fixed.
Yes. So
And
what happened today?
Today we did. It's not in the list even. The reason is on 8th of September that order has been passed.
Karmaka, you should have mentioned that before the learned trial.
Done.
Maybe by mistake.
It is also lying with the court.
Maybe Mr. Kormakar, you could have mentioned that it is fixed on for
If your
on
lordship-
19th of September.
But if your lordship sees the manner in.
Nobody knows what happened today.
But there are 5 orders. Nothing has happened. Nothing has happened. I've inquired that, taken on instruction, I'm making the submission. And the learned court's view is I'll only take High Court direction matters and nothing more.
Yes, that is only for you.
That's why
That is only for you.
asking for the direction.
That is only for you.
So that's why I'm before your lordship. Else, my lord, I won't be able to get the matter.
All matters, starting from issuance of summons, you are applying for expeditious hearing. This will happen, I am telling you. No matters will be taken up in usual course.
At least we must be doing something.
You will be facing the music, 1 or
Yes.
5 years it will not take. I'm telling you, it will take at most 1 year. See what happens after 1 year.
Lord, Mr. Justice Dotto Lord, once indicated that why should I take your hearings for expeditious hearing matters? It
Giving
should be-
preference to you.
Yes, it's a violation of natural justice.
Yes.
Justice Banerjee gave a good reason. Natural justice does not come when you stand in the queue of Sholab Shauchalaya. It's on the basis of urgency. So Lord, here is the urgency.
But
Lord, kindly fixes the matter.
Kormakar, I'm not saying that in some matters there is no urgency. Some matters there is urgency. But the way you are filing this expeditious hearing matters, none of the matters can be taken up.
I am the last person to believe, Lord, my lord passes all orders for expeditious hearing in any matter that comes before your lordship. At least
Not
I have
doing
not
that.
got that.
Not doing that.
All right, sir. I have got that.
I will remember that and apply to your case. Apply to your case.
Not got that. I have
I
already.
can start from this matter.
This is an urgent. This
I
is
can
a-
start from this matter.
This is an urgent.
This application under Article 227 of the Constitution of India
one indulgence, my lord, if I can, my lord, get the uploaded copy, my lord.
Mr. Kormakar, they are also hard.
Lord,
Indicate that you are
As
present.
your lordship kindly clarifies, else, my lord, they will again start.
The learned trial judge is
Well,
Yes.
petition is the opposite party to an
yes, Mr. Kormakar, please. একদম উপরে একটা এই প্যারাগ্রাফ লিখে দিন তো একদম স্টার্টিং এ
Yes. Petitioner is the opposite party to an application under section 5 of the Limitation Act to an application, my lord, order 9 rule 13.
You are the opposite party in order 9 rule 13. Section 5 allowed.
Allowed.
Where coming?
Yes. My lord, kindly have a look to the list of dates. The conduct.
File the
File first, my lord, kindly have a look to the first list of dates. And my lord, they.
What is the degree?
My lord, decree for my lord eviction license, eviction of license.
You have taken possession.
My lord, soon after.
Have you taken possession?
No. Because execution when the summon was served, my lord, after 3 months thereafter, my lord, kindly have a look to the list of dates first. It is not such type of case. Otherwise, my lord, I could have suggested, my lord, need not to come. You contest the suit again.
Yes. What is the special type of case in this matter?
Suit was filed 2015. Then 2015, 17, 6, 2015. They entered appearance 28 October, August 2015. Since 2015, they sought time for filing written statement. On 1st of September 2016, suit was fixed, my lord, ex parte for non-filing of written statement within the statutory period. Thereafter, again, 3 occasions up to 2017, my lord, they filed applications, petitions seeking adjournment of the suit. All these were, my lord, rejected. Thereafter, they did not appear in the suit. Suit went on ex parte and decreed in 2020. Not that, my lord, the matter was.
So, decree when? What is the date of the decree?
Date is 23rd, 16 January 2020.
16 January 2020.
2020.
And
execution, my lord, on 23rd of August 2022.
Yes. When order 9 rule 13 was filed?
12th of October 2023. Even
12th of October, 12th of December.
12th of October.
2023.
2023. Even in entering appearance, they took time, my lord, to, and the police, they said, the learned advocate's fault. This is not an advocate's fault. Conduct, kindly see the conduct. I have all the orders of the trial court. And the judgments I have relied, my lord, with the Firisti, my lord, will get the Firisti even page 52. That judgments has not been reflected in the impugned order.
Mr. Betal, an advocate appearing for the petitioner.
weeks, my lord.
Yes, yes.
Suit of
Uh,
2015, my lord.
That I appreciate. Execution has been stayed now, Miss case will be stayed.
My lord will find no reason. No reason.
I've
will be
seen that. That is why I have admitted.
Otherwise, yes. My lord, can it be some 8 weeks, my lord, if possible? 8 weeks.
8 weeks. Already 8 weeks. Contested application after 8 weeks. Thank you. Yes. Yes.
Application for amendment of claim rejected. That
Application for amendment of claim rejected.
My lord, originally we filed a suit for permanent injunction to defendant without my consent as per the beyond the agreement constructed third floor. Thereafter we filed application that amendment.
Where is the claim?
That client is not annexed, that is with me, my lord.
What is the suit for?
A suit for a permanent injunction, my lord. There we have a copy.
Suit for permanent injunction.
My lord. To take for declaration that the development agreement binding upon the party.
How can it be done now?
Lord, we
How can it be done now?
Lord,
Development agreement is dated 2017.
my lord, we obtained
Not by limitation.
No, my
And
lord.
binding, even then the suit is not maintainable. No prayer for specific performance.
No, my lord, we obtained the letter of administration in the year of 2022. I have stated my father is the original plaintiff. Therefore,
Yes, but how can you now pray? The suit was filed in 2018. It was a simplicity of suit for permanent injunction. So now you are seeking the relief of declaration.
that the
That's binding.
tenancy agreement, development agreement is binding upon.
Rightly, Ashun. This application under Article 227 of the Constitution of Forty-three yeses.
My lord, I may appear on behalf of the petitioner, my lord.
Yes, yes.
Early disposal of the order, page 52, my lord.
Order 22, Rule 3 application.
My lord,
Allowed.
order 6, rule 17, my lord, page 52, my lord. I am paying for early disposal of the suit, my lord.
Application under Article 227 of the Constitution of India. Let the information come. Yes.
My lord, this is my application, your lordship, challenging two procedural orders of the arbitration and arbitration proceeding, your lordship, and also the manner in which the arbitration proceeding has been, my lord, conducted by the learned tribunal.
Yes, yes. What are
My
the
lord-
orders which you are challenging?
Yes, my lord, I'll just indicate. Now, my lord, there was no caveat, my lord, but it was, when I mentioned the matter, it has fallen from your lordship that to serve upon the, to let the other side know. So that's why, my lord, we have already served this, but there was no caveat.
I have not said if there is no yes.
Very well, I must have.
Lord, I have informed him that's over telephone. He's inquiring and
Yes, yes. Yes.
Yes. Now, my lord, we'll find the
Right. So there is no caveat. They are appearing. You have served. No difficulty. Yes. What is the order impugned?
order impugned is your lordship regarding one recall application which I have filed.
Recall of what?
Recall of the previous two procedural meetings where, my lord, my right to adduce evidence was closed. My lord, absolutely, there's no, I cannot shy away from the records what's there. Due to non-appearance of the respondent number 2 who was appearing in person in the arbitration proceeding, this was the sole reason for which the evidence was closed. And accordingly, your lordship, I have a counter claim of 1 crore and odd, and I couldn't adduce any evidence, let alone the
chosen not to adduce evidence.
That was, my lord,
Don't say I could not.
well, I cannot shy away from that. Your lordship, what has happened? He was appearing in person and he couldn't understand what the procedural, my lord, the entire process, what was followed by the tribunal. Now, this is one application for rejection that was rejected, and secondly, my lord, my application under Order 18, Rule 17 of the CPC
18,
for
Rule 17, why?
recall of the my lord, only for a limited purpose of cross-examination of
Order
the
18, Rule
witness.
17 is court's requirement. Party cannot apply under Order 18, Rule 17.
Yes, my lord. Order 18, Rule 17 for the recall
Party
of
do not have right. It's only the court's power to seek clarification. Order 18, Rule 17, party do not have any right. The right which the party had, Order 18, Rule 17, capital A.
From that application, what I wanted to indicate is only how, my lord, one important fact that has to be, my lord, also looked
At what
upon.
stage, sir?
Final arguments, your lordship. What
Let
is
the final arguments be over?
He participated in the
I participate, absolutely.
Argument of sense.
It has commenced, your lordship. Now, my lord, what has happened? I'm also challenging the entire process. What has happened? Issues were not framed. There were two prior
Issues were not framed.
There were directions, my lord.
Non-framing of issues does not vitiate the trial. Those line of decisions are there. If the parties went to the trial after knowing the cases of the respective parties, mere non-framing of issues cannot vitiate the trial.
But my
Line of
this was the
decisions are there.
this modus operandi was, my lord, allocated by the arbitrator. How the entire process will be, first the statement of claim has to be submitted.
Yes,
then
what
the-
is the order which you are challenging? Please show me.
My lord, will kindly take the order from after page 166. The two orders are, my lord, annexed.
After page 166.
Yes, my lord. Otherwise, my lord, I'll just indicate page 144 is the 20th meeting. Page 144.
144 is the letter, I find.
My lord, this is the letter of the arbitrator, my lord.
Yes. So
And
where
there
is the
are-
order?
Order, my lord, I'll just indicate. From 145 it starts, my lordship.
What is
After
this?
page 166, just after one page of 166, your lordship will get the first impugned order. ঠিক বলছি?
Yes, yes, absolutely.
After
I
page
mean,
166.
my lord, I have also annexed. I have also annexed in the petition.
Get to page 20.
This is the minutes 20. Minutes 20.
Yes.
Just after that, the first impugned order, 13th August 2025.
13th August. Where do I? Yes, 13th August 2025.
This is the
What
first
is
order.
done by this?
Yes, this was my recall application order, your lordship, where my recall application was rejected.
Recall of what?
Recall of the earlier minutes of 10th and 11 minutes where my lord, the right to adduce evidence was closed.
You wanted recall of that.
I wanted recall of that.
So that was rejected by 13th of August.
On the ground that there was discrepancies between the erstwhile advocate who was appearing and also, my lord, the respondents who were there. My lord, what has happened?
Now,
Your
after
lordship,
that, what happened? After 13th of August, what happened?
after 13th of August, my lord, I file another application for recall of the witness for the limited purpose of cross-examination under Order 18, Rule 17. Only to assist the tribunal so that the controversies between the parties can be ascertained.
Yes. Now, after that was rejected, now you have come to challenge both.
My lord, we have been, my lord, kindly appreciate, your lordship, kindly appreciate, we have been recently engaged in this matter.
Maybe.
Now, my lord,
That cannot be a ground.
I bowed on, my lord. My lord, what has happened?
Maybe
Since the-
tomorrow someone will also come.
There won't be any tomorrow, your lordship.
Standing behind you, he may be engaged and he will come.
My lord, there's
Taking
no
another
tomorrow.
seat.
I will appear for them because both of them are very known to me. I will appear for them if I
So you are appearing in this matter, Mr. Banerjee?
just for moral support.
Yes, yes.
Now, my lord, what I want to indicate, your lordship, my sole ground was there was discrepancy with the erstwhile advocate and the, my lord, the respondent. My lord, on the ground, I'll also indicate the conduct, what has happened. My lord, after section 17 application was filed by the claimants, my lord, the respondent number 2, when he was
What is the
appealing in person-
dispute? What is the dispute?
Dispute is regarding, your lordship, a property development agreement arises out of a development agreement regarding the allocation of shares where they say, my lord, I am the landlord. I am the landlord. They are the my lord, developers. Where, my lord, agreement is dated 2012. My lord, in the year 2000, copy handover this one, 2017. My lord, only in 2017, my lord, the allocated portions were handover, not even in a habitable condition. So, my lord, there are certain discrepancies among the parties, and that has to be adjudicated by the tribunal. But until and unless I get an opportunity to adduce all the documents which I am trying to rely on, your lordship, my counter claim goes. Even I have a counter claim of 1 lakh, my lord, 1 crore. My lord, I stand corrected.
When did you file the counterclaim?
Counter claim was filed long back, your lordship, in the 4th or 5th minute meeting, my lord, in around July, August, my lord, we have filed. Now, my lord, one interesting point that has to be also take a note of, your lordship, that a prior consumer forum application is pending before the national dispute.
It's pending.
It's pending. It was.
So you will not be prejudiced if it is
No, my lord,
rejected.
what are the same grounds? Your lordship, same grounds. It was filed by me. The landlords filed before the consumer forum. And
Yes, Mr. Mukherjee, what do you say?
Subsequent to that, my lord, they have filed the arbitration proceeding and
They will be, they cannot adduce evidence.
You know, they chooses not to cross-examine me in person. My understanding is saying discrepancy of advocate. Respondent number 2 is an advocate. He filed wakalatnama along with respondent number 1. He said, he is an advocate. He was prior to at the time when the cross-examination stage comes.
Who is the advocate?
Kindly takes up the
respondent number 2 that it has been.
Petitioner number 2.
Petitioner number 2 here.
My lord, he is not a practicing advocate, your lordship.
Maybe.
My lord, he has, my lord, made an
He has
affidavit
legal
where he
knowledge.
is-
Initially, he appeared both in person for himself and the respondent number 1 in the arbitration proceeding. Thereafter, he engaged 2 of the advocates. Along with the advocates, he also appeared each and every minutes. The learned
Is the stage of the arbitration.
their argument is going on.
Their argument is
They are, and that has been closed. What happened? Their argument
When they file this application,
their argument is closed. The learned arbitrators, he prayed for, I will not argue anything else, only on the basis of the evidence which has been adduced by me. If you want certain thing to be clarified, that will be clarified on the last date.
where is that?
Yes, kindly takes up the minutes.
Show me that minutes.
Yes. 17 plus 17th sitting.
17th.
Annex corridor.
20th meeting.
No, that is not annex, my lord. I shall show.
Sorry, give it to me.
I was hoping, my lord, they would file for an affidavit, my lord.
In opposition.
Opposition and for limited stay, my lord, if at all.
Yes.
Kindly takes up, my lord. It's the 17th.
Don't
sitting.
introduce those practice in civil division.
My lord. I bow down, my lord. Only, my lord. Light and not, my lord.
The argument commences in 12th sitting. My lord is getting, my lord. Now this is the 17th sitting argument. My lord.
So after this, they file that application
Yes.
recalling.
That was turned down. They filed the second application. First application, that was turned down. That order was not under recall. The second application, first application is for not vacating the order passed on 9 and 10th and 11th.
Recall of those orders, your lordship.
First impugned order.
That is the order dated 13th of August.
Lord, that is the order dated 13th of August before your lord.
Show me that.
My lord, you file from page 144 of my.
That just, my lord, I have stated before your lordship just after 166.
Yes, I've got that page.
Yes,
Please show me that portion only.
Kindly takes up internal page 4 of the order.
Yes.
4th paragraph, it starts with, it is further submitted by placing, has your lordship?
Yes.
10th and 11 minutes of the meeting that repeated adjournments has to be sought for by the respondents in view of the fact that they had given ill advice by the erstwhile learned advocate. Ultimately, the respondent had no choice but to proceed with the arbitration proceeding in person. This is wrong submission, my lord, I shall show. However, the respondent not being fully adept with procedural niceties were unable to conduct the proceeding in an appropriate manner. It is only upon the
So
presence.
this application was dismissed with cause.
This application has been dismissed. Lord kindly takes up the now observation of the learned arbitrator.
Have you paid the cost?
My lord, it was made that cost was
paid cost, sir.
No, my lord, cost was not paid. My lord, I'll just indicate, my lord, I'll just indicate. This was dismissed on cause subject to your lordship that they can.
Then you filed another recalling.
Not recalling, my lordship.
This is
the recalling
of 10th and 11th sitting minutes. Now, second application is not even recalling of this. Second application is again prayed for. Allow me to adduce evidence. That was turned down.
No, second, not adduce evidence, my lord, only with the limited period of cross-examining the witness. Cross-examining. I am
under Article 2.
My lord, only humbly praying, your lordship. My chance to adduce, my lord, rely on any documents goes away, your lordship.
No.
And in the even I have my lord, kindly consider this. I have a counter claim of 1 crore.
Maybe.
I least heavily prejudiced, your lordship. If
Counter claim, you want to cross-examine them only.
Only them, my lord. If
how can you prove your counter claim? That's a suit.
That's a suit.
That's a suit.
My lord, I am also paying for, my lord, reducing my evidence.
Now stage by stage. You started by saying you will only cross-examine, nothing more.
When I
application under
I undertake, my lord, I'll pay the cost. Kindly allow me to adduce the evidence at least, your lordship.
How much cost you want to pay?
Whatever your lordship.
Commensurate with your claim in the counter claim. Commensurate with your claim in the counter claim.
My lord.
How much?
My lord, 5% of the counter claim, my lord. 5% of the counter claim.
5% is too meager an amount. Because if you get a decree, you will get lump sum amount.
That's also, my lord.
That is why I'm asking you.
Whatever your lordship pleases, your lordship.
But discovery
Whatever.
inspection stage, they have not done anything.
This application under Article
Well, whatever your lordship pleases, 10.
This application under
Kindly, only one observation.
what?
Point.
Non-prosecution is non-prosecution. What is the effect of non-prosecution? You know. Yes. Yes. Call the next matter. Yes.
Time for the caveat or
Yes.
Lord, a short point, the Lord involved in this case. Suit for a specific performance of contract was filed, including prayer A for declaration of title to the property on the basis of agreement for sale. Second prayer, Lord, if your lordship kindly come to the plain first.
No, what happened? Please give me the background.
Background, my lord. Second prayer was also permanent injunction in the nature of temporary injunction. Decree for permanent injunction in the nature of temporary injunction. A, B. C, a specific performance of contract. My lord, delivery of possession. For delivery of possession because of section 22B. 22B. Now, my lord, here, in our case, the trial court decreed the suit for a specific performance of contract, not the decree for delivery of possession. That was deemed to have been refused. This is the only.
Then
what happened? Then appeal was preferred.
Yes.
Appeal court also that from that same order, execute and deliver.
Impugned order.
Impugned order is that the delivery of possession has been issued. We say it is without jurisdiction. Because
show me the plaint.
Yes.
Or the prayer in the plaint.
Come to the prayer of the plaint at page 12, my lord. A decree declaring inter alia that the present plaintiffs are the joint intending purchasers of the scheduled property. Number Lord, then B. 2. A decree for permanent injunction.
Yes. So 3 and 4 is the relevant.
3 and 4. What is the decree? Lord, I am saying 1, 2 refused.
1, 2 refused. All right.
1 is deemed to have.
All right. 1 refused, 2 refused, 4 3 granted. 4 refused.
Refused. Lord, difference is, my Lord, that if I don't pay recovery of possession, then the execution stage I can pay for. Because of 22 section is says that, my Lord. Lord, now your Lordship kindly come to the degree.
Yes.
Straightway degree. Lord, degree at page, my Lord, trial court degree, Lord, at page 31, 53, let us come to 53, my Lord.
Now, what is the impugned order?
Impugned order is writ of delivery of possession be issued. I say that you being a executing court cannot go behind the decree. That is the question involved.
Where is the decree?
Yes, that is why, my
Trial
Lord,
court's
kindly
decree?
come to page 53, my Lord.
Trial court's decree is at page 53.
Page 53. Lord, kindly read the, my Lord, page 52, because that is, my Lord, handwriting.
Page 52, yes.
Page 52. The suit and the same is degreed. Lordship got it.
Yes.
Degreed on contest against the defendants.
Degree for specific performance.
Yeah, degree
Directed to execute a conveyance.
The plaintiffs are directed to deposit so and so, failing which suit shall stand dismissed.
Conveyance has been executed.
Executed and registered through court. The first defendant is directed to execute
But
conveyance.
this decree was challenged. Mr.
Decree was challenged by appeal.
You.
By appeal.
By you.
By me.
Decree stood affirmed.
Yes, now my Lord, decree is for only executing the agreement for sale.
That you have done.
The agreement for sale that I have not done, but it must be said to be have been done because I did not go, and therefore it was executed through court. It shall be deemed to be by the party. Now, Lord, your Lordship, then kindly execute conveyance in terms of the agreement which joins.
Yes, I've seen that. Yes.
Then, my Lord, your Lordship, kindly come to the. Therefore, my Lord, fourth part is refused. The fourth part is also refused. Delivery of possession.
Yes.
That is refused. Lord, now your Lordship, kindly come to the appeal court degree, page 56.
Yes. 56 appeal court has only affirmed that.
Only affirm that and directing. No, thereafter directing to execute and register a SLT.
All right. Yes.
No specific order has been given. Grant delivery of possession.
Yes.
Because my Lord, difference, draw your Lordship kind attention. Because of under section, my Lord, say specific relief act.
Specific relief.
Lordship kindly.
আমাদের কাছে নতুন বইটা আছে স্পেসিফিক Yes.
Section 22. Number 22, notwithstanding anything, may I read, my Lord?
Yes.
Notwithstanding anything, to the contrary contained in the Code of Civil Procedure, any person suing for the specific performance of a contract for the transfer of immovable property may, in an appropriate case, ask for possession, partition, and separate possession of the property in addition to such performance. Then, my Lord, any other relief to which he may be entitled, including refund of any earnest money or deposit paid or made by him in case his claim for a specific performance is refused. Lord, therefore, alternative prayer, Lord, for recovery of possession, Lord, that is inclusive of a specific performance of contract. It is implied. Lord, Supreme Court said it is implied in a case where even if that is not made, recovery of possession. But my Lord, distinction is that in that case also, Babulal, my Lord, Supreme Court in case of Babulal held that even in execution case, he can make an application for amendment of the claim. Lordship knows another judgment, 2009 Supreme Court says, my Lord, there the decree was passed, no dag number, Khutiya number. Execution case, levied, 47 out. Lord, it gone to the Supreme Court. Supreme Court said, no, got a decree. He is entitled therefore to file an application for amendment. Our case is just contrary. Prayer was made, prayer was refused. Under section 11(5). Lord, I know, Lord, where the issue will be pinching in your Lordship's mind. I know that. But what can I do, my Lord? That this is the only point. I have taken only this point, my Lord, ground number 1 and 2. And 3 pages to 4 pages, my Lord. And my Lord, I have brought the judgment on this also. Supreme Court judgment.
It is to be hard.
True. Lordship kindly sees this judgment. That is exactly on that point. Lordship,
Even if it is refused.
yes. No, not refused, Lordship. Nothing is mentioned in the decree. It is not refused.
He is taking the help of section 11(5).
True. Here also same thing. Lordship
It's-
kindly sees.
No,
this
no,
is a 1954 SCC online Allahabad 101.
Allahabad.
Yes, no. Thereafter, Lordship, the Supreme Court also has relied upon this. This is the judgment debtor's appeal. The plaintiff filed a suit for specific performance of contract and the suit was decreed. Learned counsel has stated that the plaintiff had also asked for
Yes, Mr. Chakraborty, this is a
Appeal,
interesting point.
appeal.
I will hear this.
Appeal.
Can you come
I
after?
will argue.
10:30 is fixed, Lordship, for delivery of possession.
I will argue.
Monday.
Monday.
What can be done, Lordship?
I will argue.
It's passed.
Show me the.
This is when this order was passed. It was passed on 28th of August.
And 9-9 I got it. No, I got the 9-9. Certified copy 9-9. 7 days I have taken for preparation and
They deliberately waited for such.
no, not deliberately waited.
No, Mr. Chakraborty, please show me that here the prayer was
Yes,
refused.
that
Where
is
is
not
that? Show me which paragraph.
the plaintiff suit. Lordship kindly see, but the terms. Lordship, I am again reading. This is a judgment debtor's appeal. The plaintiff filed a suit for specific performance of contract and the suit was decreed. Learned counsel has
Action was made in the decree,
Yes.
but about delivery.
exactly
Yes.
in our case.
Yes.
The plaintiff suit of specific performance of contract of sale dated such and such is decreed against the defendant and the defendant number 1 to 5 are ordered to execute a sale deed of property in dispute in favor of the plaintiff on payment of such and such. It is urged by the learned counsel that the plaintiff having claimed possession and possession not having been specifically granted in the decree, it must be deemed that the relief of possession was refused. And the plaintiff cannot therefore claim for recovery of possession.
Delivery of person.
Exactly what my learned senior friend is saying. Now, paragraph 3, we do not think there is any force in this contention. Section 55(1)(f) of the Transfer of Property Act provides the seller is bound to give, on being so required, the buyer or such person as direct.
You have the copy of the deed of conveyance.
Yes.
Please show me that.
Lordship, by the court or by the main lordship.
He has not executed that.
No, but through court it has been
Yes,
executed.
please show me that.
But through court.
Yes, yes. Because he has not executed that, you cannot rely upon that. Please show me the deed of conveyance executed by the court. Don't you have a Xerox copy of this?
Yes, I have.
Please give me a Xerox copy. Keep the original with you.
আপনার কাছে photocopy আছে? Lordship, we will supply, Lordship, we shall supply.
Please give me a minute.
Oh, this is distinguishable, my lord. This is in appeal, this question raised. In our case, appeal also refused prayer.
Please
This is not a case of
Mr.
refusal.
Banerjee, please give me a
Lordship.
minute. Yes. Please take
Lordship,
it back. Give me, yes. Give me
kindly
a
see page
photocopy
9.
of this.
Lordship kindly comes to page 9 of this deed.
Yes.
Lordship will kindly see page 9 of the deed.
Page 9. All.
Yes, the covenants, Lordship, 3, page 9.
Yes.
The purchaser shall may at any times hereinafter enter upon, enjoy and possess the said piece and parcel of land and building standing thereon and every.
Yes, yes, I've seen.
So, Lordship, after execution, Lordship, possession from therein after. Now, Lordship, this judgment, this Allahabad judgment.
Yes.
So, Lordship, considered in the latest Supreme Court decision, Lordship, reported in 2024 SEC Online 3584. Where, Lordship, it has been stated that where, Lordship, the suit property is, Lordship, is under the control of the contracting party, Lordship, no relief for possession is required, Lordship.
Where is that? Which paragraph?
Yes. Lordship will kindly come to page number 14.
Page number 14.
Yes.
Yes.
Paragraph 8, Lordship sees.
Yes, paragraph 8, 854 Allahabad
Yes,
noted.
This was also noted. After noting that, Lordship, the court came to a conclusion. So this law, Lordship, still holds. It was decided in the Allahabad case.
Yes.
Lordship will also kindly come to paragraph 19 and 20 of the said judgment at page 7. May I read it out for your Lordship? Recently, this court in such and such held that the conveyance by way of sale would take place only at the time of registration of a sale deed in accordance with section 17 of the Registration Act 1908. Till the times of such registration, no conveyance could be said to have taken place. Now, paragraph 20, Lordship. Thus, even if a suit of specific performance is decreed without a specific decree for transfer of the possession of the suit property, the same can be enforced only when the trial court directs the defendant to convey the suit property to the plaintiff by getting a sale deed registered with respect of the suit property, as it is only after registration of that transfer of title would take place from the defendants to the plaintiff.
Yes.
Then, Lordship will also kindly take up paragraph.
Yes.
Lordship will also kindly come to paragraph 23. This was what my learned senior friend was referring to. Babulal's case, Lordship.
Yes.
This court in Babulal's case, Supra, upon a combined reading of section 22 and 28(3) of the Specific Relief Act respectively and section 55 of the Transfer of Property Act, observed that it is only in appropriate case that the plaintiff was required to separately seek the relief of possession, partition or separate possession as the case may be, along with a relief of specific performance. This court observed that in other cases, say for example, a case where the exclusive possession of the suit property is with a contracting party, a decree for specific performance of a contract of sale simpliciter wouldn't specifically without specifically providing for delivery of possession may give complete relief to the decree holder. This court observed
Yes.
the mandate following 55, Lordship.
Yes.
And thereafter, Lordship, he goes to that case was, Lordship, referred to. So, Lordship, when, Lordship, the possession of the suit property.
Yes.
So, Lordship, when the possession of the suit property is with the contracting parties, Lordship, there is no need for praying of a separate, Lordship, for decree of possession, Lordship. And moreover, Lordship, in the Allahabad case, it was clearly held that even if it is not granted, Lordship, it can be granted.
Lord, Allahabad case, my lord, in appeal.
Maybe.
Not in execution case. Now, my lord, appeal order refusal. Now, my lord, implied, this is implied. I am saying that it is implied, but when it is refused, not specifically granted.
It is not refused.
And what would be the interpretation?
Mr. Banerjee, I will consider that.
But I will place some judgments, 3 judgments.
Yes.
Yes.
Lordship will also kindly come to his the trial court's judgment, Lordship.
Yes.
At page 52.
Yes.
Right before, Lordship, the ordered portion.
Yes.
3 lines before that, all the 4 issues are thus decided in favor of the plaintiffs. So it is not a case that the suit was decreed in part. And this was affirmed by this honorable court, Lordship.
Yes. Yes.
Lord, I am reading. Lord, page 52. Lord,
Yes.
1, 2 refused because no specifically given. And then plaintiff to get a decree of a specific performance of contract. First dependent so and so, then directing to execute and register a sale deed. First dependent is directed to execute a conveyance in terms of agreement for sale after withdrawing the balance consideration amount and within the last day of December 2013, failing which the decree may be put in execution. The decree may be put in execution, not, therefore specifically, Lord, language is unless specifically granted. Lord, language under section 11(5). Then kindly come to the High Court judgment. High Court judgment, your Lordship sees.
Yes. High Court in appeal.
High Court in appeal, page 69.
Yes.
Paragraph 14, my lord, page 69, paragraph 14. As such, the judgment of the trial court stands affirmed. The stand first appeal stand dismissed. Appellants are directed to execute, register a sale deed, being legal heirs of the erstwhile owner and having inherited the property within this year, that is 2023, in favor of the respondent, failing which it shall be open to the trial court to execute the required document. Lord, no specific order has been passed. Lord, this is required to be considered. I shall place some judgments before your Lordship. Kindly keep it, my lord, immediately after vacation.
Give me the judgments, Mr. Banerjee.
Yes. Lord, first of all, 11(5).
Yes. When is the date of execution?
Monday.
Monday.
Yes, I shall go into it, my lord. Kindly fix it on Tuesday. No, I shall go through the judgments, my lord.
What judgment?
They have relied upon the facts.
So, Banerjee, for you, what?
No,
what?
kindly fix it, my lord, on Tuesday. No, kindly fix it on Tuesday. I shall.
Please cite the judgments. Yes.
I shall place the judgment.
Yes.
Lord,
cite the judgments. You are ready with this.
Very well, my lord. 11(5).
Yes.
Any relief claimed in the plain.
Not expressly granted, deemed to have been refused.
Yes.
Yes.
Therefore, trial court not expressly
accepted your followed your submission that
granted.
Yes. he has prayed for the decree for recovery of possession or delivery of possession, whatever name called, that was not expressly granted, deemed to have been refused. So you are trying to make a
Therefore,
distinction.
trial-
You are trying to make a distinction between cases where, even if not prayed for, maybe implicit, but prayed for refusal, it cannot be implicit.
Yes.
That's your submission.
That is my
Any decision you want to rely upon.
Now, another thing, my lord. Even if it is not prayed for, he is at liberty to make an application for amendment.
But this is not, that is not
Amendment
the
of
case
the-
here, because it has been rejected according to you.
That's right. Now, my lord, your lordship kindly take it.
Yes, what do you want?
Come to my lord,
Specifically
section
that.
22.
Have it.
Section 22.
Yes, take it.
I have it, Lordship.
Take it. Yes. Yes.
Section 22, my lord.
22 of the Specific Act.
Notwithstanding anything to the content, anything to the contrary contained in the Civil Procedure Code, any person suing for a specific performance of a contract for the transfer of a movable property may in appropriate case ask for possession so and so, any other relief to which he may be entitled, including refund of earnest money, deposit or paid, so and so specific is refused. No relief under clause A or B of subsection shall be granted by the court unless it has been specifically claimed. Unless it has been specifically claimed, but deemed refused. Deemed refused. Provided that where the plaintiff has not claimed any such relief in the plaint, the court shall at any stage of the proceeding allow him to amend the plaint on such terms as may be just for including a claim for such relief. Power of the court to grant relief shall be without prejudice, award of compensation, etc. Now, Lord, may I place before your Lordship the judgment of the Supreme Court in 2023, Lord, interpretation of section 22.
Yes. Yes, give me the reference.
23, volume 3, 2023, volume 3, HCC, page 714.
2023, volume
3, HCC.
Yes.
Page 714.
714.
Lord, paragraph, my lord. (35). Lord, I am placing before your Lordship. 830.
Yes. Paragraph?
Paragraph 35. On a plain reading of the
You
above.
don't have a photocopy. You don't have a photocopy.
Lord, I have a photocopy, but difficulty is this, my lord. Photocopy does not tally with this.
All right.
I can take a Xerox and then I can submit.
Yes. Please place paragraph 35. Yes.
Because your lordship sees that paragraph 31, then I have tallied with the, that is 35.
Yes, give me a photocopy of this.
Lordship.
Yes, please.
On a
Paragraph
plain
35.
reading of the above reproduced provision. Lord, entire provision has been given.
Yes.
Lord, only before that, we may refer to section 22 of the Specific Relief Act.
Yes.
Paragraph before
Yes, I have
35.
seen that.
Which provides that any person suing for a specific performance of the contract for the transfer of property may ask for possession or partition and separate possession of the
That is
property.
being quoted in. It has been
In
quoted.
section.
No. Yes. Paragraph
Section.
35.
Because, my lord, the view is because under the Widow Adoption and Maintenance Act, section 19, right of maintenance is that is your defendant number 1. And this is the only dwelling house. There is no other dwelling house. And that is why 1 unit is. That is why, my lord, SLP was preferred.
Please take your seat, Mr. Koth. Yes. Please take your seat. Yes.
Lord,
Yes.
that is why SLP was preferred. And SLP was withdrawn because the hardship question in terms of section 10 was not taken into consideration. That is why review has been filed. It is pending.
Before the Supreme Court.
No, this court, because Supreme Court withdrawing. Now, my lord, the
144 is there, Mr. Banerjee. 144 of CPC is there.
Yes, that's right. Is there, but the question would be that it is refused. Now, Lord, paragraph 35, on a plain reading of the aforesaid reproduced say provision, we have no reason to doubt that the plaintiff in his suit for a specific performance of a contract is not only entitled to seek a specific performance of the contract for the transfer of immovable property, but he can also seek alternative relief, including refund of earnest money, provided that the relief has been specifically incorporated in the plaint. The court, however, therefore, my lord, court, however, has been vested with wide judicial discretion to permit the plaintiff to amend the plaint, even at the later stage of the proceeding, and seek alternative relief of refund of earnest money. The limited test appears to be that unless the plaintiff specifically seeks the refund of earnest money at the time of filing of the suit or by way of amendment, no such relief can be granted to him. The prayer clause is sine qua non of grant of refund of the earnest money. Any applying these principles to the facts in hand, we find respondent has neither paid for relief nor refund of earnest money in the original plaint, nor he sought an amendment at a subsequent stage. In the absence of such a prayer, it is difficult to accept that courts would suo motu grant the refund irrespective of the fact as to whether 22(2) of the Specific Relief Act is to be construed directory or mandatory in nature.
Yes.
Therefore, Lord, in any case, Lord, my respectful submission here in this case, earnest money, and that case, Lord, when a specific performance of contract is given, possession is implied. In the case of earnest money, alternative relief, when a specific performance is refused. But when a specific performance is granted,
possession
implied. But question is, my lord, that if possession is specifically prayed for
and refused,
but not granted, not granted, specifically granted. This is clear from the judgment of the trial court as well as appellate court. For doubt. But therefore, Lord, this is first judgment. I am not disputing. I shall distinguish the judgment of my learned friend which he referred. I am coming to that. Lord, then your lordship kindly look to that here also the same. Lord, Desraj case, my lord. Desraj versus Rohtak Singh. Lord, here also the same principles, Lord, have been given. এটাতে reported case তো বলতে পারবো না, civil appeal 921 of 2020.
Yes.
That is Desraj. Supreme Court. Lord, paragraph 31, my lord. Paragraph 31.
Yes.
Firstly, we may refer to section 22 of so and so, which provides that any person suing for a specific performance of contract for transfer may ask for possession for partition, separate possession. In addition to performance, such person may seek any other relief to which he is entitled, including refund of any earnest money or deposit paid or made by him, in case his claim for a specific performance is refused. However, subsection 2 puts a caveat as aforementioned reliefs shall not be granted by the court unless it has been specifically claimed. Proviso to subsection 2 further says, if such relief was not specifically claimed in the relief, it is the discretion of the court to permit the plaintiff to amend the plaint at any stage of the proceeding and allow him to then part. Then my lord, it has been quoted here. Then your lordship kindly come to the applying these principles to the facts in hand. We find that the respondent has neither paid for relief for refund in the original nor is sought for amendment at any in the amendment of or subsequent stage. In the absence of such a prayer, it is difficult to accept the court's suo motu grant refund of earnest money to money, irrespective of fact as to whether section 22(2) is to be construed directory or mandatory in nature.
Yes. So this is that relief has to be specifically prayed for.
Then implied in the, and then if it is not given, not is specifically prayed for, implied in a case if it is specifically prayed for, and not implied in the case of a specifically prayed for, then 11(5).
Yes.
Lord, this is the only ground I have taken in the divisional application. Now, another judgment, your lordship kindly see that 2001.
Mr. Banerjee, what is the citation of this? Or
this is
Devraj?
Devraj citation, my lord. This is from net I have given. My lord, I can give the citation. That is why I am coming on Tuesday, my lord. I can give the details thereof.
No. I will try to search it out. Yes, next.
All right, my lord. I have given that judgment to your lordship.
Yes.
Devraj, my lord, I have given. Now, my lord, 2001. ওটা দাও, এটা এনেছি, ওটা দিয়ে দাও।
2001
আরে ও বোঝেনি, এই এটা দাও, এই যে অ্যাডকন ইলেকট্রনিক্স প্রাইভেট লিমিটেড, এখানে আছে অ্যাডকন ইলেকট্রিক্যাল প্রাইভেট লিমিটেড, my lord.
2001?
Yes, my lord. I am giving the paragraph, my lord. Paragraph 80.
17 SCC.
That was considered in 2024 SCC online.
2001
SCC. 2001?
7 SCC 698.
698.
98.
698. Yes.
Lord, Adcon, my lord, in paragraph.
What is the proposition you want to rely upon?
Proposition, my lord, is that unless the relief is sought, but no relief can be granted because by virtue of section 22(2). Now, my lord, here relief is sought
and refused.
That is mine. Lord, here towards the bottom of this page.
এটারই রিলাই করে, এটাই ওটার লাস্ট প্যারাগ্রাফ।
Yes.
Enabling provision, my lord, no relief under so and so shall be granted by the court unless it has been specifically
that. Mandate of
Lord,
section 22.
now, Lord, specifically it has not been granted by the degree. Then, my lord, it shall be deemed to have been refused. He ought to have, Lord, under order 41, rule 33, even in a cross appeal, no cross appeal need be filed. Cross objection need be filed under order 41, rule 20.
There may not be a case of cross objection because if your submission is accepted, relief claim refused. So if a part refusal of a degree, so he has to prefer an appeal. It's a cross appeal, not a cross objection. Cross objection is only with regard to some finding, because here if your submission is to be accepted, a part of a relief is rejected. Rejected, so you ought to have, they ought to have
That
preferred
he
a
cannot, my lord, up to
appeal.
Supreme Court judgment, my lord, order 41, rule 22. Lord, he can support the decree by arguing that it ought to have been added by exercise of power under order 41, rule 33.
Yes.
He ought to have. But, my lord, that prayer was not granted because I cannot be evicted, my lord, contrary to Article 300 capital A. Let him come in accordance with the constitutional law. 300A is the protective umbrella on my part.
Of the Constitution.
Of the Constitution.
Protective umbrella of the
Of that is 300 capital A of the Constitution. But that is why I am arguing only on that. Only on that. That is why I want to, my lord, read further, my lord, and argue before your lordship in extenso. Lord, that I want.
You have argued
That
in
time.
extenso, Mr. Banerjee.
Lord, anyway, my lord, this is a critical question, my lord, which is required to be. Required to be. That your lordship only puja days, my lord.
Only
during puja, Lord, widow lady. And my lord,
don't ask me to tax my.
No. I am sorry. I'm sorry, my lord.
No. It need not be. Some is on a lighter vein, Mr. Banerjee. Don't take all observations seriously.
Yes. Now, my lord, so far 2024, they have said, Lord, with regard to that part only, that this is not a case where it can be thrown out at this stage. This is a case which is required to be decided. And 11A, some judgment are I shall place it.
11.5.
11.5. 11.5.
11.5 statute is clear. These are well settled proposition.
Well settled proposition.
For that, Mr. Banerjee, you did not cite.
That I need not cite.
Relief claim not expressly granted, deemed to have been
refused.
It's well
Exactly,
settled.
my lord. That is my contention. Now, my lord, with regard to 2024 HCC online, which my learned friend, that I want to read, my lord, then I can place before. Otherwise, how can I distinguish and how, my lord? It is a longest judgment. No. My lord, may I tell you, lordship? But if I want to argue,
Babulal. He also cited Babulal.
yes, Babulal, but there is a distinction between Babulal. Babulal also relied on. Babulal case, my lord, amendment was placed. Amendment was allowed. Babulal case is not a case where decree for specific performance was granted, affirmed by the, and even in spite of deemed refusal, it is not a case of Babulal. Therefore, Babulal case, my lord, is distinguishable. And this case is also distinguishable. Lord, that is I want to read the entire. Otherwise, how can I argue? Lord, give me 1 day time. Because I cannot be evicted on Monday. The lordship kindly fix it on Tuesday, my lord.
Monday, 10:30. Monday, 10:30 only to.
Monday, 10:30, I will be evicted. 10:30 is the time in the impugned order.
10:30?
Yes. That is the reason I am telling your lordship.
Till Friday.
All right. But come on, I'm fixing this on.
Lord, I want to argue before your lordship on this.
Mr. Banerjee, you have argued only for distinguishing this judgment. Nothing.
Now, distinguishing, let us place then.
Yes, 2024. I'm recording
2024.
that. Heard Mr. Banerjee, learned advocate for the petitioner.
Want to grant me liberty to application for temporary custody of my child.
Yes, yes.
Tomorrow is the date. Well, if the order is uploaded, well, the learned court is not.
সেদিন
এই নাম্বার
কালকে আমি প্রথম ওটা সই করেছি।
The next matter, my lord, where my minor child is, my lord, is directed to be handed over to the father, my lord.
Some fixed matters গুলো today,
Tomorrow, today, my lord, immediately next matter, my lord.
46 টা রাখুন। Yes.
Matter number 46.
But there was a caveat, my lord. Yesterday, my lord, gave leave from your lordship, my lord, to file list this matter, and there is caveat I have served, my lord.
You are for the caveator? Yes.
My lord, this petitioner challenges, my lord, the order whereby, my lord, the wife is being directed to file an affidavit disclosing, my lord, the probable action which is to be taken for, my lord, handing over my 2.5 years old child to the father for custody for 3 consecutive days during puja time. My lord, in an application filed by the petitioner, husband for her wife. My lord, lordship, can have a look at the order impugned, my lord.
Yes.
My lord,
What is the difficulty?
My difficulty is, my lord, this petitioner, there is a matrimonial suit, my lord. In 2023, petitioner got married. 23rd.
Oh, then don't bring those facts.
My lord.
What is the difficulty in handing over the child?
Custody, my lord. The child is, my lord, 2.5 years of age.
No order has been passed till.
Till it, no order. My lord, can you have a look at the observation?
File the affidavit.
My lord, can you see, my lord, that the observation itself shows that the learned court has made up of his mind. My lord, for my assessment, kindly have a look at the last
Yes.
My lord, last para, upon hearing both the side of the considering, last 12 to 13 lines, my lord.
Yes.
The type of attitude, the minors are like flowers, and they in the middle, my lord.
Yes, yes.
Minors are like flower, and they should be they should be given the scope to flourish in the compound of both our parents. The minor, if given to the custody of father, it would not vitiate the tour plan of the opposite parties, and the OP can surely enjoy her tour plan without the child. If she wants, she can go on touring, letting the child to the page, enjoy the puja with her father. In my considered view, while granting the scope of visitation, the dispute between the parents and their mutual arrogance is hardly any bearing. The minor may easily be given to the custody of the father, even though a girl child, if the father is equipped with the assistance and help of any adult female member for taking immediate care of any of the child. In the petition for custody, the father has not mentioned as to under whose immediate care and custody that during the proposed period. In my considered view, the minor can be given in the custody of the petitioner if he by affidavit submits a detailed plan regarding receiving of the minor, details of the adult female family members who take care of the minor child, and on which date he is supposed to hand over the child. My lord will kindly consider, my lord, the child is a breastfeeding baby, my lord. From 6 months onwards, from 6 months, the child is under the custody of the wife, my lord, and he's been residing separately. But in my objection application, I specifically stated that I have no objection if the visitation is being given to the petitioner, to the father. Visitation, he is ready to visit the child with the child, my lord.
How do you propose the visitation to be made? What is your proposal? Let
specific time frame, time be fixed in presence of the parties, my lord.
Tell me, in presence of
both the parties, my lord. Mother will the child to the father, and they will both there. They will
remain there.
Remain there, but not, my lord, in my matrimonial home.
Where?
Well, any other places, because, man, the matrimonial suit is pending, and 198 case is also pending, my lord.
That's the difficulty.
My lord.
That is why. So you are saying that you are agreeable. One hand you are saying mother is agreeable, and in the same breath you are saying there's a 498.
My lord, there's a visitation, right? Visitation is already there, my lord.
Yes, yes, visitation. So you said the mother has to be present there. So if the mother has to be present there, if the mother is willing, I will allow the mother also to go to the matrimonial home for a brief period.
But matrimonial home cannot go, my lord, because, my lord,
where
any specific place subject to lordship consideration, whether
it suggests which place.
Just well, may I just take instruction, my lord.
An observer was appointed.
Any public place, my lord, any public place.
So please suggest, I'm
South
asking.
City Mall, he's suggesting South City Mall, any other places near.
From which period to which period?
কোন সময়? সময়, time. Any time from 12 onwards in the afternoon.
How much time?
2 to 3 hours, 5 hours.
2 to 3 hours or 5 hours?
My lord.
In a public place, any mall or something? Where do you stay?
Jadavpur, he resides in Jadavpur.
Where do you stay?
Ashoknagar.
Mr. Rai, considering the age of the child, so if the mother has to accompany the child,
We don't have any difficulty.
so he agrees for 5 hours.
Yes.
So 5 hours, he says that in any mall, South City Mall will be nearer to the residence of the wife, because that has to be considered. Because convenience of the child cannot be brought to your place. So if that is so,
Actually,
please
in
suggest,
all her affidavits, she has stated that she resides in North 24 Parganas, but for this particular visitation, she has stated that she is staying in,
yes,
yes, Lordship.
sitting in Jadavpur, she has now agreed for 5 hours.
Yes.
So in South City Mall, you are agreeable?
Yes, yes. Yes, Lordship. Your Lordship will kindly pass the necessary order after going through the report of the observer, which was printed by the learned court below.
Observer, Mr. Rai, please, for the time being, keep aside that observer.
No, these incidents happen.
So 5 hours they are willing. In South City Mall, do you have any problem?
South City. Actually, since the child is of 2.5 years, he is suggesting if it could be arranged in any residence. Means he has a residence. Ashoknagar, he has his residence. She has also.
You want to go to her residence?
Yes, he is willing to go.
If he is agreeable to go to your residence?
Yes, my lord. She has no problem, my lord. Not in Durganagar, my lord. Jadavpur, right? Presently, she is residing, my lord.
Jadavpur? Except your client, who else is residing there?
Jadavpur, Lordship, that will be difficult.
Why?
Right,
you can come to South City Mall in Prince Anwar Road, and it's difficult for you to go to Jadavpur.
Because there is a threat of life. There is a recording also.
That is who else accepting your client is residing there?
Her maternal uncle house is there, in Jadavpur.
She's her residence
in that house or in that flat, whatever it is. Who else is residing?
Her residence is at Ashoknagar, Lordship. Her residence is at Ashoknagar.
But her mother accompanies her in that particular place where he is
staying there.
Staying there, my lord.
In the order sheet only, your Lordship will kindly find the residence of the wife. Page 3, middle portion.
Yes, where is your client residing?
Well, presently, my lord, that was his permanent address. But now, my lord, he is residing in Jadavpur, Survey Park, my lord, which is South Chobbish Pargona. But for which, my lord, the petitioner has also filed an application trying for transfer of this particular case, my lord.
No, that I understand. Try to take a cause of action for that transfer
No, my
petition.
lord, I am not trying, my lord.
That I will clarify.
Yes,
my lord,
Don't
no, my
try
lord.
to make
No,
that.
My lord, no, I
with
followed
Mami.
Lordship,
What is your status of that occupation in that property?
My lord.
In what capacity you are staying in that property at Jadavpur?
My lord, as tenant, my lord.
Tenant under? Since when?
November 2023, my lord.
Do you have the rent receipts?
Rent receipt, sir. My leave and license is there, my lord. Rent receipt is.
Now you are saying to leave and license. First you started with tenancy. Now you are shifting to leave and license. Show me the leave and license payment receipts. Any payment receipt or without any payment?
With payment, my lord. Payment.
Receipts.
Only one agreement has been produced for that work. He has a residence in Ashok
in Ashok also.
Yes.
Ashok residence.
Durganagar, my lord.
Durganagar.
She had a residence, my lord. She can once take her child to Durganagar for visitation, my lord.
Yes, Durganagar, where except your client, who else is residing there?
Nobody resides there, my lord. It is vacant, my lord.
But any special officer during that period? Suggest.
Should be. The special officer. Yes, Lordship. Your Lordship will kindly ask special officer.
Yes, yes. Any special officer, he or she must be, it's preferably if she is a lady, within residing in that locality. Otherwise, during puja, it will be difficult to travel. Yes, any member of the bar, young junior member of the bar who resides in that locality. Whether she is agreeable, she will be where she is residing. Also, so he's saying Ashok Nagar.
Durganagar, Durganagar.
Not Durganagar. Parasat. Mr. Rai, can you come down to Jadavpur? Because it might be difficult a practicing advocate getting there, local advocate.
She's suggesting a name of Moushami Kushari, who's practicing.
Moushami?
He was here. Yes.
He will be agreeable.
Okay.
Yes. In the presence of a special officer, 5 hours.
4 to 5 is right. As a lordship.
No, be specific. 5 or 4.
As a lordship, please, as I
5 hours and on 4 days of the puja.
During it will be difficult for her to carry the baby.
She will be staying there.
But there is no amenities to stay there.
She
stay. Jadavpur is already.
Yes.
Yes, madam.
I'm saying at Jadavpur. I'm requesting him
Yes,
at
yes,
Jadavpur.
yes. No.
Jadavpur, 29th, 30th, 1st and 2nd.
As a lordship, please.
So from which time will be convenient?
Means Jadavpur. In Jadavpur.
Yes, yes. What will be the convenient time?
From morning?
Is give a time. 11 to 4?
11 to 4, my lord.
But Mr. Rai, allow the child to take lunch. Don't say I have control over the child. I will not allow to take lunch.
But in Jadavpur, in her premises, my lord.
No, you can offer. He's asking, we cannot offer any food to the child.
Offer food. You can offer food, but please see that.
There are some past incidents. That is what I am saying.
Yes, my lord.
For that special officer, I am providing for the special
officer is there, my lord.
Yes, what should be the remuneration? Per day. What should be the remuneration?
Be divided by both the parties.
Consider that this is the puja time.
10,000 rupees.
Per day. Only 10,000, Mr. Rai.
Only?
Only 10,000 I am asking you. 4 days making 50,000.
50,000.
Consolidated.
To be paid by both the
10,000
parties.
per day for 4 days because conveyance and other things.
To be borne by both the parties.
Both the parties, this is their application, man.
No, they are also working. She is working.
This is the ground.
Working.
Yes.
This is the this is for the working, my lord. They have never paid a single penny, but not a single instance, my lord. They could pay, my lord. But they have filed the application. Let them pay, my lord.
All right, I can do one thing. You
Then
need
wait for tomorrow.
advocate on records of both sides.
My lord, my lord.
Yes, I think.
Lordship,
Yes, yes.
kindly.
Both of you pay. Yes. I think
Lordship,
that-
lordship will lord.
Why?
My lord. My lord. My lord, this.
There will be no difficulty.
My lord, lordship will kindly not do that. My lord,
You will not pay anything.
no, lordship will.
Then how much you will pay?
But
How
per
can
day,
it be
3,000 to
this?
4,000 rupees she can bear, my lord.
Per day,
Per day, 3,000 to
4,000.
4,000 rupees.
You pay the balance. 4,000. So for 4 days is 16,000. You pay the balance.
My lord.
This application under Article 227 of the Constitution of India
He also stays in Santoshpur. Please take the.
You are stay. Where are you staying? Uh, uh, at the suggestion of the learned advocate. Is she in court? Have you taken her consent? You have taken consent. Give the
Phone number to give.
phone number. It will not be given in the order.
No. I
Phone
will.
number. Give it to them. Please give the name.
Nina?
Put, yes, put it in that piece of paper. The name of the special officer, the address টা incorporate করে দেবেন. Protection
And returnable on.
Disposable.
Special officer will file a report.
you.
No. Special officer has to file a report, Lordship.
আচ্ছা
Yes.
তাহলে এটা করে দিন. On the basis of this, in view of this order, nothing remains to be decided. No, in view thereof, it is made
I'm so sorry.
430.
My lord, item number.
Yes, please give the address of the Jadavpur and the name of the special officer.
My lord, item
Yes,
number.
Mr. Rai, please keep.
My lord, item number 60, my lord. I'm so sorry, my lord. Becoming infructuous, my lord. There was an order directing freezing of an account.
Yes.
That was passed in the appellate court.
Come on Monday.
My lord, but it's item number 60. They are withdrawing the amount. It has been ex parte varied by the honorable judge while extending the interim order. On the basis of that order of varying, the amounts are being taken out.
When that order was varied.
That order was varied on 4th of September. We have filed the revisional application immediately without the certified copy.
I'm taking it up on Monday.
Monday, kindly keep it at the top, my lord. Kindly, my lord, 60.
Item number 60 ta Monday.
Also in respect of 436, Mr. Bhattacharya is there. Small matter, my lord, only he is supposed to.
It's difficult.
On Monday, my lord.
Mr. Nag, please see, these are the urgent.
Let it remain.
Mr. Nag, if I find time, I will. Please see these urgent matters. You will have some urgent matters.
Yes, he will have 10.
So I will do that. When if you have any urgent matters, if you and Mr. Bhattacharya, instead of that matter, I will take this matter on that day.
Kindly let the matter be at 4 p.m. on Monday. My lord, for Monday it may be in the list at 4 p.m. My lord.
If other matters, other urgent matters are fixed before 4, I assure you I will take it up. Provided you allow me to take it up at 4. Other matters.
Let it be there in the list at Monday.
4, 5 days.
What is the
Only
ruling
4.
urgency? You have not
Practically 4 days left. Not even 5. Practically 4 days left before vacation.
It is best, Milord. Keep it for the ends of justice, Milord. Me, humbly, Milord, I am requesting the Lordship to kindly keep it on the first Tuesday after reopening. First Tuesday.
Let it remain in the list. I'm not fixing now because you will be enjoying the long vacation, not within the.
I will be very much within. Very much within.
Nobody knows where he will be good.
In that event, I am supporting his submission, my lord. Let it be fixed on, my lord, reopening Tuesday, first Tuesday.
First Tuesday after vacation.
Lordship fix it.
Oh, first Tuesday at a date.
Fine.
At 2 p.m., my lord. 2 p.m. will be fixed.
1 line.
2 p.m.
Our key. 2 p.m.
Only for your benefit, I am not fixing it at 2 p.m. I do not. For me personally, I do not have any difficulty in fixing any matter at 10:30 also. I do not have any difficulty. It's only for the members of the bar I am fixing these matters at 4 p.m. Only for that. And today you have taken a resolution. See the clock.
Well, in that event, we are safe because Mr. Bhattacharya on last occasion promised that even if there is resolution, he will do that. Well,
Yes. Now this they have to also transcribe. Look, in the other matter, they have said that tomorrow I have permitted Mr. Karmaka's matter.
one line order.
Which item? Which item?
436.
Item number 436 at order record korun to.
Matter is fixed first Tuesday.
In the joint prayer. Yes.